Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. Today is Monday, April 26th. It is 10 a.m. We're here today in dockets number 2019-264E and 2019-265E. This is the Duke Company's IRP. Before we take roll, please join me in a brief moment of silence. Thank you so much. Let's take roll. Present in the hearing room are Commissioners Caston, Vice Chair Belzer, and Chairman Williams. Joining us virtually, we have Commissioners Powers, Thomas, and Urban. Okay. Let's take appearances from the parties, starting with the applicant.
Good morning, Mr. Chairman. And I don't know if it matters, but we don't see you on the WebEx screen, and maybe that's just the way it's working this morning, but I recall being able to see you previously. Regardless, I'm Rebecca Doolin. I am in-house corporate counsel for Duke Energy Carolinas and Duke Energy Progress. Ms. Heather Shirley Smith, who is also in-house corporate counsel, will be joining us hopefully later this week. She is out for a medical procedure right now, but hopefully she will be joining us soon. Together with me, I have a few outside counsel. I have Frank Ellerby, who is with the law firm of Robinson Gray. I have also Sam Wellborn, who is also with the law firm of Robinson Gray. And I also have Brett Breichwert. Mr. Chairman, he's happy to walk you through that name once he gets going, but Mr. Breichwert is with the law firm of McGuire Woods out of Raleigh. And those are that is counsel for the companies for the applicant, Mr. Chairman.
Thank you, ma'am. Carolina's Clean Energy Business Association.
Mr. Chairman, members of the commission, I'm Richard Witt from the Witt Law Firm. Also appearing on behalf of SECEBA is John Burns, who is the general counsel for SECEBA. Also appearing is Ben Snowden from the Kilpatrick Townsend Law Firm, and attorneys Burns and Snowden were both admitted by this commission pro hoc vici.
Thank you, sir. South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Sierra Club, Natural Resources, Defense Council, Upstate Forever.
Good morning, Mr. Chairman. Kate Mixon on behalf of South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Upstate Forever, Sierra Club, and Natural Resources Defense Council. And also with me today is Gudrun Thompson, who has been admitted pro hoc vice in this proceeding. Thank you.
Thank you, ma'am. Johnson Development Associates.
Yes, sir, Mr. Chairman. Weston Adams here with Nelson Mullins for Johnson Development. My partner, Court Walsh, will be here for the entire proceeding. I will be here just this morning, if that's okay with Mr. Chairman.
That's fine, sir. Thank you for letting us know.
Yes, sir.
Vote Solar.
Good morning, Mr. Chairman. Taylor Spear for Vote Solar. Appearing with me is the company's regulatory manager, Tyler Fitch.
Thank you, sir. Good to see you again. Cherokee County Cogeneration Partners.
Mr. Chairman, Commissioners, this is Jack Pringle of Adams and Reese here on behalf of Cherokee Cogeneration Partners. I'm making a limited appearance to ask that I could be excused. As much fun as this looks like, I'd like to ask to be excused from the hearing as we don't sponsor any witnesses and don't intend to conduct any cross-examination.
You are excused, Attorney Pringle. Thank you for joining us briefly. All right, Nucor Steel. I believe Nucor Steel, South Carolina, filed a motion to be excused earlier in this process, and they are excused. Office of Regulatory Staff. Attorney Bateman, we cannot hear you, sir. We still have no sound, Attorney Bateman. Still no sound, Attorney Bateman.
Mr. Chairman, can you hear me now?
Loud and clear.
Okay, thank you, Mr. Chairman. Good morning, Mr. Chairman. Representing ORS is myself, Andrew Bateman. Along with me in the room, I've got Mr. Nelson, also representing ORS. Thank you, Mr. Chairman.
Yes, sir. Let me note for the record that Commissioner Carolee Williams, representing District 1, is on leave and will not join us for this proceeding. Are there any preliminary matters we need to take up before the first witness is called?
Mr.
Chairman, excuse me, Richard, this is Frank Ellerby. We would, request, that the commission hear us, in an oral argument in support of the motion to strike that we filed last week.
Yes, sir.
We think it's important, and, we'd like an opportunity to speak to that briefly this morning at the beginning of the hearing.
All right, go right ahead.
Thank you, Mr. Chairman.
Attorney Ellerby, I think you may be on mute.
I don't know how I got back on mute, but thank you for pointing that out. The motion to strike that we filed addresses primarily two reports that were submitted by the interveners, environmental and solar interveners, as part of their testimony attached as exhibits to their rebuttal testimony. And we have made several different arguments as to why those reports and the testimony relating to those reports should be stricken from the record, not admitted into the record, and not considered, not discussed in the proceeding. I'm going to focus today on the Act 62 issues, the arguments we made that what they have asked this commission to consider is inappropriate under Act 62. That to us, that's the most fundamental flaw here in what they've asked y'all to consider. And this is one of the very first Act 62 IRP proceedings. And we think that the commission should take special care in how it addresses these issues because they're going to be precedent setting. And we think the idea of submitting something like what has been submitted at the last minute before it has been fully vetted is absolutely contrary to what's required under Act 62. And what I'm talking about is subsection C1 of 583740, which was a critical part of the General Assembly's treatment of integrated resource planning in Act 62. And that there's an unusually specific provision in subsection C1 that says the commission shall establish a procedural schedule to permit reasonable discovery after an integrated resources plan is filed in order to assist parties in obtaining evidence concerning the plan, including the reasonableness and prudence of the plan and alternatives to the plan raised by intervening parties. What's critical is that all the parties have an opportunity to investigate, to develop evidence, to submit testimony addressing both the integrated resource plan as proposed by the utility and alternative plans proposed by other folks. And that procedure is illustrated very nicely in this case, in this proceeding. The company proposed its IRP. The Office of Regulatory Staff retained outside experts to examine. That expert consulting firm sent out hundreds of requests for data. Based on those data requests, those companies prepared a report which was submitted as as an exhibit to their direct testimony. That report contained 25 recommendations for the company to address regarding the integrated resource plan. the company in its rebuttal testimony, addressed the 25 recommendations from the ORS experts. When ORS filed its rebuttal testimony responding to what the company had said about the recommendations, we were left with 2 recommendations remaining. So that's the type of vetting process that the General Assembly had in mind when they put this provision in Act 62. You put it out, you put your plan out there, there's ample opportunity for discovery, there's testimony filed, responding testimony, rebuttal testimony, responding to that. You get a narrowing of the issues, and you get, very importantly, you get the back and forth as exhibits to the testimony of the witnesses. And then you get those witnesses fully informed, fully understanding what the assumptions on which the plan was based. You get those witnesses testifying before the commission. The commissioners get an opportunity to read that testimony with the back and forth and the point and counterpoint, the response. You get all of that in advance of the hearing. Contrast that with what has happened with respect to the Synapse report, which is an alternative integrated resource plan that is submitted by the solar and environmental parties as an exhibit to rebuttal testimony 12 days before the hearing starts. The companies have had no opportunity to submit rebuttal, or any testimony or put up witnesses who have had a sufficient opportunity to fully understand the assumptions underlying that study and prepare to testify and submit testimony. And more importantly, this commission has had no opportunity to see and read testimony addressing it. So to contrast that with what happened with the ORS witnesses and how they examined the company's IRP, y'all have seen all that. You've had an opportunity to review all that and get familiar with it, and you can come prepared to the hearing to ask questions. Nothing like that has happened with respect to the Synapse report. Nothing like that has happened with respect to John Wilson's all-source procurement report. Those reports raise new issues that have not been properly vetted. I would ask you to, in considering this issue, we would ask that you take judicial notice of the joint comments of the South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Carolina's Clean Energy Business Alliance, and Sierra Club, filed in docket 2019-226E last week, the 20th of April. That's the Dominion docket. Dominion filed its modified IRP in response to this commission's order about its integrated resource plan last fall. It was submitted, and y'all had the hearing last fall. Dominion filed their modified IRP, and last week, the same environmental and solar interests that are involved in our case submitted comments. And I do not pretend to know the merits, and I'm not speaking to the merits of the underlying issue in that case, but I will tell you that the environmental and solar parties strongly objected to the Dominion proposal for a short-term plan to replace certain combustion turbine gas generation units. And their complaint was primarily that there was a complete lack of transparency and that there was insufficient time to fully vet that plan that Dominion proposed. And again, I don't know whether that's the case or who's right or wrong, but the point is the fully vetting of the proposed plan. We absolutely agree that that's important, that's critical, that has to be done to be fair to this commission, fair to the Office of Regulatory Staff as ORS tries to do its job and required by the General Assembly, ORS needs a full opportunity to do for alternative plans what it did for the Duke plan. So we ask you to follow the advice, what the solar and environmental parties said with respect to the Dominion, that short-term plan that hadn't been fully vetted. They said, let's consider it next time. There's no reason to rush to consider it right now. It can be proposed and fully vetted the next time there's an update, or the full plan can be the next fully revised Dominion IRP. We think that's what should be done here. We think y'all should not consider, you should grant our motion to strike. You should not consider the Synapse report and the other things that are listed in our motion to strike. We should strike the testimony, and we should not be going into matters that haven't been fully vetted. Not fair to the companies, not fair to the commission or ORS. Thank you, Mr. Chairman. Nothing further.
Response.
Yes, Mr. Chairman, this is John Burns, the General Counsel of CCEBA. I'll be speaking on behalf of CCEBA and also on behalf of the other interveners, but I do want to say that there are other counsel here for some of those other interveners who may have some input, but I'd like to at least first begin by responding to Mr. Ellerby's argument, if that will be okay with you, Mr. Chairman.
Yes, sir. Please proceed.
First, I think I'll just take Mr. Ellerby's arguments in order. We did submit a memorandum which I think sets out pretty clearly why this motion to strike should be denied, and I refer the chairman and the commissioners to that response that we filed on Friday. But I'd like to just take some of the arguments that Mr. Ellerby has made this morning and see if we can't come to a head on those issues. First of all, as to Act 62, it appears to me that Mr. Ellerby's argument is at least founded on the misapprehension that the Synapse report is an alternative IRP. It's not. It's not an alternative IRP, and to characterize it as such is just incorrect. It is commentary on the IRP submitted by the Duke companies. Act 62 requires a procedural schedule to permit reasonable discovery as to the IRP, and so that the parties can sort of join the issues. Mr. Ellerby is exactly correct on that, and that's what we're doing. And if I could direct the commission's attention to page 5 of Ms. Wilson's testimony, where she sets out her recommendations. None of those recommendations in Ms. Wilson's testimony are that the Synapse report should be adopted as an alternative IRP. That's not the way it's intended, and that wouldn't make sense. It is, however, an extensive critique of the company's IRP, and the invitation is for this commission to send Duke back to modify its IRPs to address some of the issues brought up by Ms. Wilson and again by John Wilson and Kevin Lucas, who also refers to the Synapse report. It is a critique and exactly the type of evidence and testimony that the procedural schedule and Act 62 are designed to elicit. So we ask that you, if that's the basis for the motion to strike, we ask that you deny that motion. Furthermore, the entire motion by the companies is at least premised on the idea that there was unfair surprise here. And as pointed out in our motion, our response to their motion to strike, we'd just like to remind the Duke companies that they were served with the Synapse report in North Carolina on March 1st. They were served with John Wilson's all-source procurement reports on March 1st and have had full access to that and done this extensive discovery related to the statements in those reports and in the testimony that Ms. Wilson and Mr. Wilson provide. There is no unfair surprise here. We did produce this information in response to the rebuttal testimony of the Duke witnesses. So it is proper sur rebuttal, and that argument is extensively set out in our memorandum. So it's under South Carolina law, any arguably contradictory testimony or evidence is proper on reply or sur rebuttal. And that's what we have here is evidence and testimony given in reply. Finally, Your Honor, not only does Duke seek to exclude the testimony and exhibits of Ms. Wilson and John Wilson, They also seek to exclude any reference to the Synapse report or the all source reports by any other witness presented by the interveners. That is contrary to Rule 703 of evidence in South Carolina, which allows an expert to rely upon the type of information they would rely upon in their profession. And clearly the comments and statements of someone with the expertise of Rachel Wilson and John Wilson are the kinds of evidence and information that an expert such as Kevin Lucas might rely upon in commenting and critiquing a document such as the IRP here before you. We'd ask that you exercise your broad discretion in allowing testimony. This is not a jury proceeding. You are a panel of experts and are fully able to provide the proper or grant the proper weight that you consider is proper in considering all of the evidence that's before you. At the end of the hearing, you can give the weight to whatever testimony, give proper weight to whatever testimony you wish. That is within your authority as members of this commission. So in sum, we just say that this testimony is proper. It is goes right to the point of what Act 62 asks this commission to decide. And we'll get into the points that these witnesses and these exhibits bring up. But clearly, it is critique and it is shows that the IRPs presented by the Duke companies are inadequate and not the type of IRP that should be approved under Act 62. So we ask you to deny this motion, and I'm happy to answer any questions you might have. Thank you.
Thank you, sir. Anyone else? All right, motion denied. Oh, I'm sorry, was it?
Oh, I apologize, Mr. Chairman, but it sounds like I didn't need to speak anyway. I was having trouble getting off mute. Mr. Chairman, I believe I was talking over you, so I may have not heard the commission's ruling.
Yeah, I was ready to make a ruling, but I do not want to limit your opportunity to respond.
Oh no, that's quite all right. I don't think I have anything important to add. I was struggling to get off mute, but I don't think it's necessary at this point.
Mr. Chairman, Frank Ellerby, and I will make it very brief. Rachel Wilson, who is a witness who is one of the authors of the Synapse study and is a servable witness, describes her plan as laid out in the Synapse study as an alternative resource plan. So I disagree with Mr. Burns when he says that it's not an alternative integrated resource plan. That is what it is. It's characterized by the person who wrote it, who is a servable witness. So thank you for letting me clarify that.
Absolutely, sir. And obviously, council knows that at the end of the hearing, all motions may be renewed, but at this time, your motion is denied. Anything else before we get started?
Mr. Chairman, Richard Witt for Carolinas Clean Energy Business Association. We submitted, along with our witness plan, a request for a short, around 5 minutes opening statement by Attorney Snowden, if you will allow that.
Yes, sir, I will allow that. Obviously, that opportunity will be given to all parties. But before we start with opening statements, are there any other preliminary issues?
Mr. Chairman, good morning, Rebecca Doolin for the Duke companies. We wanted to touch base with the commission with regard to the schedule associated with the hearing going on over this week and potentially next week. We do have one witness's availability that we wanted to discuss, and I think that would be informed by what the commission's plan is in terms of the schedule over the next few days. I've noticed on the commission's website that the hearing was scheduled to continue on a Saturday, and I wanted to confirm if that was the chairman and the commission's plan in terms of the schedule so that witnesses could plan accordingly, and also that we could work the scheduling constraint we have with Mr. Herndon, who is one of the Duke rebuttal witnesses.
Yes, ma'am. Thank you for bringing that up. That was one of the things that I was going to address once the parties addressed any other preliminary matters. So the schedule for this proceeding is as follows. We will start at 9 a.m. For the remainder of this hearing, with the exception of this Thursday, April 29th. We will start at 10 a.m. on April 29th. And we will go until 6 p.m. Yes, Saturday is reserved for us to continue with this matter. I hope that we don't have to conduct a hearing or continue the hearing on Saturday, but we have a hard deadline of Wednesday. And so depending on how far we get, we'll make a determination on Friday as to whether or not we need to continue on to Saturday. But the schedule is 9 a.m. to 6 p.m. With the exception of Thursday, April 29th, and obviously today. We will go from 9 a.m. to 10:30 and have a 15-minute break. 10:45 to 12:15, have a 15-minute break. Go to 12:30 to 1 p.m. Have lunch from 1 p.m. to 2 p.m. We'll go from 2 p.m. to 3:30 with a 15-minute break. 3:45 to 5:15 with another 15-minute break, and close out 5:30 to 6 p.m. Each day. Now, if we are close to finishing up a witness, I'm not ruling out going a little bit longer than 6 p.m., but 6 p.m. is the target stop time for the hearing each day. Any questions?
Yes, Mr. Chairman, this is Gudrun Thompson. I did notice that the commission's regular business meeting is still scheduled on Wednesday, I believe. Will the hearing just recess for, excuse me, for that and then reconvene?
Yes, ma'am, it will.
Thank you.
Mr. Chairman, it's Rebecca Duglin. I was curious if there is a schedule of order of appearance of the parties, understanding the applicant will present its case first. I had not seen an order of the interveners. I know that my understanding is it's general practice that you all go in the order in which each entity intervened from a timing standpoint, but I didn't know if you had solidified that. It might just help in everyone's planning to know what entity was going to appear after the companies.
Yes, ma'am. So what I have in front of me is as follows. After the company presents its witnesses, I have Carolina Clean Energy Business Association. I have next South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Sierra Club, Natural Resources Defense Council, and Upstate Forever. Johnson Development Associates has no witnesses. Then I have Vote Solar. Cherokee County Cogeneration Partners has been excused. Nucor Steel has been excused. And then I have the Office of Regulatory Staff.
Thank you very much, Mr. Chairman. And to let you know and the parties know, we do have a scheduling constraint with Mr. Jim Herndon, who is a third-party expert witness who is a rebuttal witness. And I think we can address that as we get further through the hearing. He does have good availability next Monday and Tuesday, and so that may be an appropriate time to hear him, but I wanted to let you all know that from the outset, and we're happy to talk about it further, but given that he's a rebuttal witness, it may make sense to let's get going and then see how we do and then address that in the next few days, if that's pleases the commission and you, Mr. Chairman.
That's fine. That's perfectly fine. Okay.
Thank you, Mr. Chairman. That's all I have in terms of the preliminary housekeeping matters that I was hoping to understand. So thank you for your indulgence and clarifications.
Absolutely. Is there any objection to me calling the parties in the order that I did when taking appearances for opening statements? All right, hearing none. Duke Companies, please give a brief opening statement. If you so desire. No, not obligatory.
Thank you, Mr. Chairman. I'll be very brief. Mr. Snyder, who will be the company's first witness, will cover a lot of opening preliminary type matters with regard to the company's efforts here. But just briefly, as you're aware, this is Duke's first IRP proceeding under Act 62, and the companies have expended tremendous effort to develop an extensive and robust plan that goes far beyond the requirements of Act 62. In addition to the over 400 pages making up each IRP, and that doesn't include the attachments, the IRP also includes 3 detailed and comprehensive studies that were conducted by third-party experts in their fields. And in fact, those individuals responsible for those studies will be appearing before you as witnesses in this proceeding to explain and defend their studies. In addition, you'll hear from 7 Duke witnesses who will address a wide range of topics that are identified in the IRPs. This team is led by Mr. Glenn Snyder. His experience in resource planning and his enthusiasm to talk with you about it is evident in the hundreds of pages of testimony that have been prepared for this case. I just wanted to mention the value that the companies place on stakeholder engagement efforts that led to this IRP. We began engaging stakeholders over 14 months ago. We've held 5 different stakeholder events, and they were attended by over 200 representatives. Collaboration, engagement, and transparency are priorities that drive this commitment to stakeholder engagement in developing our resource plans. I also want to note the significant work that the companies have done to address ORS's recommendations to the IRP. Through the robust rebuttal testimony we prepared, we resolved 24 of ORS's 26 recommendations. There are only 2 recommendations left, and those are the 2 that we disagree about. And as a result, the ORS no longer recommends that the companies conduct a modified IRP. And I think this effort shows the company's commitment to providing analysis and supporting data that goes far above and beyond the industry norm. So, Mr. Chairman, the companies look forward to putting on their case to you, and I truly mean that. These witnesses have spent considerable time preparing to talk with you all, and it's very important to them. And I'll just close by pointing out that this team of witnesses that you'll hear from are those who are personally responsible for the complex and unique task of transitioning Duke's legacy generation fleet to a cleaner energy future, while at the same time ensuring costs to customers remain affordable and that the lights stay on. And I think it's important to remember that no other intervener carries that responsibility. Thank you, Mr. Chairman, and we look forward to spending the next few days with you.
Thank you, ma'am. Carolina's Clean Energy Business Association.
Thank you, Chairman Williams. I just want to make sure everybody can hear me. All right. Thank you, Chairman Williams, Vice Chair Belzer, member of the commission. I'm Ben Snowden here for the Carolinas Clean Energy Business Association, and it's a pleasure to be with you here today. As this commission recognized in its order on Dominion Energy's IRP, the 2019 Energy Freedom Act, or Act 62, enacted major changes to resource planning requirements in South Carolina. Driven by a desire to inject additional competition into the electricity arena, to advance clean energy, and to protect customers from funding billions of dollars for misguided generation projects in the future, the General Assembly gave this commission the power and the obligation to review utility resource plans and to approve them only if the commission determines that a plan represents the most reasonable and prudent means of meeting the utility's energy and capacity needs. Now, that is a serious task, and to fulfill its duty, the commission needs accurate and complete information on the costs, benefits, and risks of all available resource options. Act 62 says that the IRP must analyze this information and the range of possible resource plans in a way that fairly evaluates the range of demand side, supply side, storage, and other technologies and services available to meet the utility's service obligations. Now, CCBA appreciates that Duke has put a great deal of time and effort into preparing this IRP. A lot of smart people worked very hard on doing this, and the IRP provides reams of data and uses very sophisticated modeling techniques to arrive at its results. Unfortunately, this very sophisticated plan has some very serious flaws that keep it from providing the fair evaluation that Act 62 requires. Some of these flaws may only be apparent to experts in utility modeling, and some of them are just common sense. Now, some may only move the needle a few percent here or there, and some of them have a very big impact all on their own. But the total effect of all these flaws is to slant the analysis in Duke's IRP towards building more company-owned natural gas and away from meeting its customers' needs with additional renewables and energy storage. CCBA's witnesses Kevin Lucas and Arnie Olson will explain to you a number of problems with Duke's analysis, as will the witnesses put up by other interveners, including ORS. But here are a few examples. First, Duke's analysis is supposed to fairly evaluate all reasonable resource options, including additional solar. As of now, Duke gets almost all of the solar on its system from long-term contracts with third parties. But the only new solar Duke considers in the IRP is owned by the company and built at costs that far, far exceed the prices that Duke is already getting from third parties through competitive procurement and other programs. This is an issue that Mr. Lucas will discuss, but ORS's expert also identifies this as a problem that should be fixed now. What's more, when looking at the value of solar to its system, Duke assumes that only about 60% of new solar facilities will have panels that adjust throughout the day to track the sun. These facilities have much higher production values from sun up to sundown, and in fact, because they perform so much better, almost all large-scale solar farms that are now being built have this tracking systems. Now, Duke doesn't dispute this, but the IRP still assumes that only about 60% of facilities do this. That inaccuracy unfairly penalizes solar as a competitive resource in the IRP. Nor does Duke consider the significant impact on solar capital costs that will result from the extension of the federal investment tax credit. Another problem is Duke's failure to accurately model the benefits of combining solar and battery storage. As you will hear from witness Olson of E3, the combination of these resources provides significantly more bang for the buck than either resource can deliver separately. And Duke's modeling virtually ignored those synergistic effects and the savings that they could deliver for ratepayers. Again, not a fair evaluation of these technologies. A final example is Duke's forecast of natural gas prices. Now, gas prices are vitally important for comparing the performance of different generation portfolios. Plans with a heavy gas build will cost ratepayers much more than advertised if future gas prices are higher than what Duke assumes. But as you will hear from Mr. Lucas, Duke does not use reliable means to project gas prices. It relies too much on isolated market snapshots, which is unreasonable and imprudent compared to a forecast based on long-term fundamentals. The result of lower gas forecasts, as ORS's expert also notes, is to make gas-powered energy look better relative to renewables. Taken as a whole, the testimony you will hear will show that Duke's IRP, while it is sophisticated in many ways, still contains serious flaws that keep it from fairly evaluating the value of renewable energy and storage to Duke's customers. As a result, the IRP falls short of the standards and aims of the Energy Freedom Act. Duke's witnesses have testified, and Duke's attorneys may try to persuade you that CCBA wants the commission to force Duke to build more solar and storage, and that CCBA and the other interveners don't care about ratepayers and they don't care about reliability. This is simply not true. Now, CCBA does believe that solar and renewables, especially when combined with DSM and energy efficiency, can reliably meet customers' needs at low costs. The Synapse report, prepared by witness Rachel Wilson, shows this and responds to those specific objections by Duke. What we are asking the commission to do is require Duke to go back, take their thumb off the scale, and conduct an analysis that fairly evaluates the long-term benefits of solar and storage to customers. This is what the commission ordered Dominion to do to address the deficiencies of its IRP, and it's appropriate here as well. We also believe that this is consistent with the requirements of Act 62 and is in the best interest of Duke's customers. Thank you so much for your time and your attention.
South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Sierra Club, Natural Resources Defense Council, Upstate Forever.
Thank you, Mr. Chairman and Commissioners. This is Kate Mixon, and I greatly appreciate the opportunity to be here today. This is now the second IRP proceeding under the Energy Freedom Act. And as the Commission recognized in the Dominion IRP proceeding, in this docket, the Commission must determine whether or not Duke's 2020 IRPs are the most reasonable and prudent means of meeting the utility's energy and capacity needs. As you will hear from our witnesses over the course of this hearing, Duke's IRPs fall short of that reasonable and prudent standard because they do not meet Act 62's key IRP requirement to fairly evaluate all resource options using the best available data and tools. First, as Ms. James Wilson will testify, Duke relied on resource adequacy studies with significant methodological flaws, leading Duke to include higher than necessary planning reserve margins in their IRPs. Getting the planning reserve margin right is important because excess reserves mean excess costs for ratepayers. Second, even though demand-side management, including demand response and energy efficiency, would reduce total system costs for ratepayers, we'll hear from our witness, Jim Gravatt, about how Duke relied on overly conservative estimates of their DSM and EE potential to develop their low, base, and high DSM cases for their IRPs, meaning that those IRPs also underestimate the amount of DSM Duke could deploy to save its ratepayers money. The result is that Duke's IRPs stack the deck against clean energy resources like renewables, storage, and energy efficiency, and in favor of building more gas plants. But as Rachel Wilson's testimony will show, increased deployment of solar, battery storage, and DSM and EE are in fact essential to a cost-effective and reliable resource portfolio that meets Act 62's most reasonable and prudent standard. And John Wilson's testimony recommends an alternative all-source procurement approach that would avoid many of the disputes about pricing and resource availability that are at issue in this proceeding, and better ensure that Duke arrives at an optimal resource mix that will reduce costs and risks to customers. Lastly, I'd note that Duke relies heavily on the fact that it will be filing another IRP in 2022 as an attempt to circumvent robust commission review of this IRP. Duke witness Glenn Snyder claims that it would be too costly and burdensome for Duke to have to modify their IRP when it's already working on an IRP update. But Act 62 requires that the commission determine whether Duke's IRPs, meaning the IRPs before it today, are the most reasonable and prudent plans as of the time the plans are reviewed. As the commission also recognized in its decision on the 2020 Dominion IRP, a promise to do something in a future IRP does not make up for legal deficiencies in a current IRP. The commission should not allow Duke to keep kicking the can down the road. It should ensure that Duke's current IRPs are the most reasonable and prudent plans for the companies. Thank you again for your time and consideration, and that concludes our opening remarks.
Johnson Development Associates.
Yes, sir, Mr. Chairman. Weston Adams for Johnson. No opening from Johnson this morning, sir.
Thank you, sir. Vote Solar.
May it please the Commission. Commissioners, Chairman Williams, I'm Taylor Spear, and I have the pleasure of representing Vote Solar. Vote Solar intervened in the docket for a simple purpose: to save Duke Energy's South Carolina ratepayers what could be nearly $5 billion over the next several decades. The evidence will show that this is the amount of avoidable waste and present value that South Carolinians will bear if the commission approves the base case resource plan the companies present for approval. Vote Solar is pleased to present in this docket the testimony of its regulatory manager, Tyler Fitch. Many are already familiar with Mr. Fitch's work in authoring what has been referred to in public discourse as the Carbon Stranding Report. Mr. Fitch's forecasting and analysis presented in the report and his pre-file testimony illuminate a fatal flaw in the company's resource plan. An irreconcilable conflict exists between Duke Energy's well-published goals to decarbonize the grid and the resource plans the companies propose here. The evidence will show that Duke's 2050 net zero carbon goal cannot be achieved under the base case that the companies asked the commission to approve without South Carolinians bearing the weight of significant stranded assets. Fitch's report shows if Duke Energy is serious about achieving its 2050 goal, that the companies will construct new generation assets, but then be constrained by their greenhouse gas emissions and be forced to pull them offline well before their useful life. Fitch opines that some new gas plants will operate for less than 15 years, despite being engineered and rate-based for up to 40. The hearing evidence will show Duke Energy is very concerned about financial risks of climate change to their operations. These risks are acknowledged in the corporation's public records and financial statements. These risks are incorporated in Duke Energy's enterprise risk management process and into the corporation's impending and much touted integrated systems and operating planning. The companies will admit, however, that these risks are not fully fleshed out in the resource plans presented in this docket. Commissioners, as you hear this evidence, please ask yourself this question. Why does Duke Energy incorporate these risks in significant parts of their operations, but ignore them when the financial returns from building a new generation asset are on the line? This is not a novel ask. Act 62 gives the Commission the authority to regulate economic and other risks borne by the utilities, given the privilege of providing retail electric service in South Carolina. Section 58-37-40 was established in part for this purpose. The company's resource plans cannot be reasonable and prudent while the utility admits it did not conduct an analysis of the physical, economic, and policy risks associated with climate change. Vote Solar asks, therefore, that the Commission reject the company's resource plans and affirmatively find that managing climate change risks that are undisputed to exist is in the public interest and a necessary component of a reasonable and prudent integrated resource plan. The Commission's discretion in this regard and in this proceeding will have real consequences for the immediate and long-term stability of the companies to meet their service requirements. Fitch's report is not an academic exercise. The companies have announced plans to open an RFP for nearly 0.5 gigawatt of new gas this year. Finally, Commissioners, I leave you with 2 words: path dependency. It is undisputed in this proceeding that shoring up the company's assets against climate change risk is paramount, and this is a multi-decadal endeavor. Path dependency means if we succeed in insulating the companies from the worst effect of climate change in the future, it will be because of decisions of commissioners such as yourself today. Thank you for your time and attention, and we look forward to getting to the evidence.
Thank you, sir. Office of Regulatory Staff.
Morning, Mr. Chairman. ORS has no opening statement in this docket. Thank you.
All right. Is the company ready to call its first witness?
Yes, Mr. Chairman, I'm going to hand things over to Mr. Breitschwert, and he'll get us going. Thank you very much, Mr. Chairman.
No problem. Well, before we call the first witness, let's take a 10-minute break. We'll start at 11 a.m.
Thank you.
Thank you.
Good morning, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina's hearing and docket numbers 2019-264E and 2019-265E. Let's take roll. Present in the hearing room are Commissioners Caston, Belzer, and Chairman Williams. Present virtually are Commissioners Thomas, Irvin, and Powers. Company, please call your first witness.
Thank you, Mr. Chairman. Good morning. My name is Brett Bryceworth, outside counsel for Duke Energy with the law firm McGuire Woods in Raleigh. I just want to, for the record, note that I was granted pro hoc vice status by the commission on March 31st of this year to appear in these proceedings. I think as Ms. Doolin mentioned, I have a long 13-letter German last name, and so it's Breitschwert. If that's helpful to the commission, if anything comes up, we're going to be spending a good bit of time together over the next week. So I just wanted to clarify that for the record. So at this time, if it pleases the commission, Duke Energy calls Mr. Glenn Snyder to the stand. Good morning, Mr. Snyder.
Good morning, Mr. Breitschwert.
Mr. Attorney Breitschwert, if you would allow us to swear the witness in. And also,
yes,
I've been reminded that our court reporter needs to have parties identify themselves before they start speaking. So if you would, before you start speaking, if you would just briefly identify yourself moving forward. Thank you so much. All right. Mr. Glenn Snyder, if you would please take the stand, sir. It looks like you're already there. If you would raise your right hand, sir. Mr. Snyder, do you solemnly affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, sir?
Yes, I do.
All right. Thank you, sir. Please proceed.
Thank you, Mr. Chairman. Again, this is Brett Bryceworth on behalf of the Duke companies. Mr. Snyder, would you please state your full name for the record?
Certainly. Good morning, Chairman Williams, Vice Chair Belzer, Commissioners. It's a pleasure to be with you today. My name is Glenn A. Snyder.
And Mr. Snyder, by whom are you employed and in what capacity?
I'm employed by Duke Energy as Director of Integrated Resource Planning and Analytics for the Carolinas.
And did you cause to be pre-filed in these dockets direct testimony consisting of 36 pages?
Yes, I did.
And do you have any changes to your direct testimony at this time?
Yes, I have two small changes. First, on page 9, line 17 of my testimony, I'd like to replace the word system with the word jurisdiction. So my testimony now reads, it is important to note that DEC and DEP cannot develop different IRPs for each jurisdiction. Second, on page 29, line 9, the word plans should be replaced with portfolios. So the sentence now reads, the 2020 IRPs identify and present 6 portfolios that fairly reflect the range of demand side, supply side, storage, and other technologies and services that are available to meet the utility's service obligations under various possible sensitivities and scenarios.
And Mr. Snyder, subject to those two corrections you just identified, if I were to ask you the same questions today that appear in your pre-filed direct testimony, would your answers be the same?
Yes, they would.
Mr. Chairman, at this time, I would ask Mr. Snyder's pre-filed direct testimony to be entered into the record as if given orally from the stand as corrected this morning.
Mr. Snyder's corrected pre-filed testimony will be entered into the record as if given orally from the stand.
Thank you, sir. Mr. Snyder, did you also cause to be prepared any exhibits to your direct testimony that were pre-filed with the commission?
Yes. I sponsored the 2020 IRPs for DEC and DEP as my DEC Exhibit 1 and DEP Exhibit 1, respectively. My Exhibit 2 was the executive summary of both companies' IRPs for convenience. My Exhibit 3 was the 2020 IRP Stakeholder Engagement Summary Report prepared for the companies by consulting firm ICF.
And DEC Exhibit 1 and DEP Exhibit 1, as well as the joint DEC-DEP Exhibit 3, included limited and confidential information which was pre-filed under seal. Is that your understanding?
Yes.
And your Exhibit 1s also reflect corrections that were pre-filed with the Commission on November 6th of 2020. Isn't that correct?
Yes.
Okay, thank you. And do you have any further corrections to your exhibits at this time?
Yes, I have one small correction. I would like to make one revision on page 343 of the DEC IRP and page 337 of the DEP IRP that has been identified in response to discovery from the ORS. I would like to delete the following sentences at the end of the first paragraph on these pages. The sentence deleted reads, finally, one cost that DEP does not account for are end-of-life costs for disposal and recycling of battery storage components. Just over half of the respondents account for these costs, and the company will evaluate adding end-of-life costs in future IRPs. It's the sentences to strike.
Thank you. And Mr. Chairman, to ensure the record is clear, the companies will file a corrected page 343 of the DEC IRP and a page, corrected page 337 of the DEP IRP, as Mr. Snyder just identified, which my understanding from co-counsel is the standard practice for corrections that have been made from the stand of late. And with
That's
that,
correct.
I would ask, thank you, sir. And with that, I would ask Mr. Snyder's exhibits, including the corrections made today, be marked as the next hearing exhibits, and that the confidential version of the DEC and DEP Exhibit 1s, as well as the combined DEC and DEP Exhibit 3s, remain under seal.
All right. And sir, would you please turn your microphone down just a bit? All right. So Snyder Exhibits 1, 2, and 3 will be admitted into the record as a composite exhibit. That will be Exhibit 1 with the confidential portions of those exhibits remaining under seal.
Thank you, sir. And do I sound better now? Is that coming through all right?
I'm being told that we will not know that until your witness responds to your question.
Okay. And Glenn, could you audio check before we get going to make sure your audio is coming through well also?
Yes, I can do an audio check now. Does that work for the commission?
If you would cut your mic down just a tad bit more.
Okay. Is this any better? Hopefully that helps a little.
All right. So we do a sound check one more time.
Okay, doing a sound check from witness Snyder, seeing if we're still getting feedback.
I think we are good to go.
Very good.
The attorney, I'm sorry, I'm sorry, Attorney Brightsworth. Am I saying your name right? Brightsworth?
Brightschwert, yes, sir.
Brightsworth.
That's it.
I'm being told that you need to turn your mic down a little bit more.
Okay. Sound check for Attorney Brightschwert. How does that sound?
You sound great, Attorney Brightsworth.
Great. Thank you, sir.
Okay, now I'm being told that you need to turn your speakers down. All right. Whoever thought we would come to this with the hearing, right?
I can agree with that.
Mr. Snyder, could you do a sound check for us?
Certainly. I did turn my speakers down, and hoping this resolves the issue, I do have IT available here if we still are having issues.
All right. Are we good in the back? All right. I'm getting a thumbs up in the back. Sorry for the the issues. Gentlemen, please proceed.
All right, thank you, sir, and please stop us if we need to adjust again. But Mr. Snyder, thank you for introducing your pre-file direct testimony, your exhibits. At this time, I'd like to walk you through your direct testimony to provide a brief summary for the commission. I'd like to start out on pages 2 and 3 of your testimony, where you describe your professional experience to the commission. Can you please provide the commission an overview of your experience in the power industry as described in your direct testimony?
Yes, as I mentioned earlier, I am currently Director of Integrated Resource Planning and Analytics for DEC and DEP, and I'm directly responsible for the company's resource planning in the Carolinas. However, I've worked in the power industry for over 30 years. I actually started my career in the late 1980s as an associate analyst for the Illinois Department of Energy and Natural Resources. In that role, I was responsible for assisting in the review of Illinois Utilities' integrated resource plans. In the early 90s, I moved to Florida and worked for Florida Power Corporation in various analytic roles, doing economic analysis of energy efficiency, demand-side management, and other customer-facing programs. In the late 90s, I worked as a risk management analyst for the company's non-regulated trading group before moving to the Carolinas in 2001. Over the next decade, I served as manager of risk analytics for Progress Energy Ventures and director of transaction structuring for ArcLight Energy Management, an energy-focused private equity firm, before returning to the utility industry in 2009. Since the merger of CP&L and Duke Energy almost a decade ago, I have directed the resource planning function for both DEC and DEP.
Thank you. And I'd like to turn now to your testimony on or about page 5, where you explain that the purpose of your testimony is to sponsor the company's 2020 IRPs and to provide the commission an overview of how those IRPs comply with the requirements of Act 62. Can you please summarize that testimony for the commission?
Yes, the 2020 DEC and DEP IRPs were purposefully prepared to conform with the requirements of Act 62 and to meet all statutory requirements for approval by the commission. Our IRPs present 6 long-term resource planning portfolios that together provide a framework to navigate the company's energy future and to allow the companies to affordably and reliably serve our customers' energy needs while improving the environmental footprint of our resource mix. These 6 different resource portfolios also include numerous individual sensitivities and scenarios to the inputs as contemplated in Act 62. In my testimony, I provide an overview of the IRP's goals, preparation, contents, methodologies, and key conclusions, and explain the stakeholder engagement which preceded and informed the IRPs. I also introduced the company's 6 other witnesses that contributed to the company's IRPs and help demonstrate how these plans meet the new requirements of Act 62. The most effective way to provide the commission a high-level overview of the 2020 IRPs presented in my testimony is to briefly walk the commission through the DEC-DEP combined system portfolio results table on page 16 of the executive summary of the DEC and DEP IRPs. This is also included as my exhibit 2 for convenience. If Mr. Breichwert would be able to pull that up, please. So Commission, what you see on the screen is simply a summary table. And for convenience, this might be an easier way to walk through some of my direct testimony. As I said, first and foremost.
Mr. Snyder, I hate to interrupt you, but I'm going to ask council to enlarge the exhibit.
Okay. Tell me when is that the, I think this size here, Mr. Chairman, is probably the maximum size that presents the whole exhibit. If you'd like me to enlarge it further, I can do so, but it won't be able to have the whole exhibit on the screen.
I think that's good, sir.
Okay, and just for the commission's information, if you turn to page 16 of Mr. Snyder's Exhibit 2, this same figure is presented there if the commission would prefer to view it in hard copy in their files.
Yes, sir. And to all the parties, if you wonder why we're so meticulous, why our production staff is so meticulous about the sound and the exhibits, the proceeding is being live streamed. So there are folks that are viewing this from the web. And so we want to make sure that they can hear and see the same things we hear and see in the exhibit room. If you would just keep that in mind. Thank you.
Yes, sir. My wife is tuned in today, so I'm doing my best to speak clearly and make sure that my exhibits are well presented. So thank you for that clarification.
So, are we good? Sound doing good?
Yes, sir. Please proceed.
All right, thank you. So first and foremost, the 6 portfolios are fully consistent with the intent and requirements of Act 62. The companies developed these resource portfolios with the purpose of fairly evaluating a range of demand side, supply side, storage, and other technologies and services available to meet the utility service obligations. So if I could just, for brevity, go through some of the key facts in this. The 6 portfolios I outline in detail in my direct testimony, but this is a nice slide that compares them side by side. And so as you can see, the company, as you look down the rows, looked at the environmental impacts associated with each of the portfolios, having both a 2030 and a 2035 reduction in carbon from a 2005 baseline. You can see various trajectories of carbon reduction. We showed residential bill impacts associated with each of the individual portfolios by 2030 and 2035. Other metrics include the revenue requirements associated with each portfolio. We have Witness Roberts, who will be before the commission to talk about the transmission investments and grid investments required for each of the portfolios. And as the commission can see, the grid investments grow throughout the portfolios as you add more distributed resources across the system. The amount of solar contemplated in the IRPs vary from where we're at today, which is an industry-leading combined company, has about 4,000. But what we're showing within our IRPs is a doubling to nearly a quadrupling, depending on the portfolio. So significant advancements in the amount of solar. We have Witness Kalemba that will be talking about our solar assumptions, our wind assumptions, and other renewable assumptions here for the commission. For the first time in the company's IRP, we have both onshore and offshore wind contemplated in some of our portfolios as those technologies continue to evolve. We have the inclusion of small modular nuclear reactors in some of our portfolios, an emerging technology that's coming into play in the industry. We show incremental storage ranging from 1,000 to 7,000 megawatts in the various portfolios. And as you can see, the more renewables you add, the more storage that gets added in the various plants. We do have incremental gas resources, predominantly to replace, as a reliability resource to replace retiring coal units. And the amount of gas varies from one portfolio to the other. We have demand side management and energy efficiency programs considered at both the base case level as well as an accelerated case in the last 3 portfolios. And finally, we did do a significant amount of work, I'm sure we'll talk about in the days to come, around our coal retirements. And so we have included a most economic coal retirement, which did a very detailed economic analysis of the ongoing costs and retirement, when's the most economic retirement date for our existing coal resources, as well as an even more aggressive earliest practicable coal retirement scenario. Finally, and I think this is an important point for the commission to pause on for one moment, is this bottom row that has these little icons, sometimes I think we call them in testimony Harvey balls, really depicts each portfolio's current situation as it relates to both technology and policy. So the base without carbon policy is fully developed as a least cost plan under today's regulations and much more reliance on today's technologies. As you move further to the right, the other portfolios become ever more dependent on both policy improvement as well as technology advancements. So that really is a broad summary. Sometimes a picture's worth 1,000 words. And I think this graphic in the executive summary is a good one to show just the summary of the tremendous amount of work that was done to create those.
Thank you, Mr. Snyder. And just to clarify for the commission's information, on page 16 here, is it that this is the combined system portfolio for both DEC and DEP, excuse me. But you also present individual portfolios by utility on page 17 of the respective executive summaries. Is that the way you've designed these executive summaries in your exhibits?
That is correct. In a lot of cases, we will show both individual and joint. Sometimes it's instructive to be able to see the total system between the two utilities, and other times it's instructive to look at the individual utility itself. And so we've presented several summary tables that look at the individual utilities as well as the collective. So rate impacts, for example, are utility specific rate impact estimates, whereas when you look at total energy, because we're sharing energy between the utilities, sometimes that's more instructive to look at it from a joint. So we have both included in the plan.
Thank you. And Mr. Snyder, next in your testimony, you spend a number of pages starting around page 8, providing the commission an overview of the company's stakeholder engagement efforts that preceded the filing of the 2020 IRPs. Can you please summarize that testimony for the commission?
Yes, I put those pages in my direct testimony, really echoing Ms. Doolin's opening comments to emphasize that the company did tremendous stakeholder engagement prior to the filing of the IRPs. We included a broad range, including the ORS, public staff, several different customer groups, a broad range of environmental advocates were in attendance, and really anyone else who wanted to attend. I think we had some developers attending those as well. And that took place over multiple months going into the development of the IRP. We engaged nationally recognized consulting firm, ICF, who has expertise in IRPs. They conducted an IRP 101 webinar and included many virtual forums. The company made available in these forums a broad range of internal stakeholders from within the company. And as I mentioned, I provide the ICF report on the stakeholder as Exhibit 3 to my testimony. In addition to my testimony, I point out that the company even developed a stakeholder website and stakeholder engagement page that's on the company's website at duke-energy.com/IRP.
And Mr. Snyder, you conclude your direct testimony by emphasizing for the commission that the company's 2020 IRPs are reasonable and should be approved as total plans. Can you please summarize your testimony explaining why the IRPs were filed and why the company is asking the commission to approve them as total plans?
Yes. The portfolios presented in the IRPs fulfill the requirements of Act 62 and present a total plan that can adapt to changing standards, technology, and policies. The base scenario is designed to meet traditional least cost standards and appropriately recognizes the legal and regulatory obligations that exist today, while the IRPs also evaluate other pathways that help the companies plan for and inform future technological developments and regulatory and policies evolutions. The companies believe this is consistent with Act 62 which directs the commission to approve the IRP if it is the most reasonable and prudent plan to meet our customers' capacity and energy needs at the time the plan is reviewed. My testimony, the IRPs themselves, and the testimonies of all of the company's witnesses demonstrate that the 2020 IRPs appropriately balance the criteria identified by the General Assembly, including addressing reliability, affordability, compliance, and environmental regulations, along with other factors in Act 62. DEC and DEP went well above and beyond the requirements of Act 62 in developing the IRPs and engaging the stakeholders. And my testimony recommends the commission find that the 2020 IRPs fully comply with the act and that they should be approved.
Thank you, Mr. Schneider. Mr. Chairman, at this time, Mr. Schneider is available for examination by the parties and questions from the commission on his direct testimony. At a later point, we will be putting up his rebuttal testimony.
All right, thank you, sir. Carolina's Clean Energy Business Association.
CCB does not have any questions for Mr. Schneider on his direct testimony.
South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Sierra Club, Natural Resources, Defense Council, Upstate Forever.
Thank you, Mr. Chairman. This is Kate Mixon. We also don't have any questions for this witness on his direct testimony.
The Johnson Development Associates.
Good morning, Mr. Chairman. Court Walsh for Johnson Development. We don't have any questions.
Vote Solar.
Well, it looks like I'm the only one taking the bait. Taylor Spear for Vote Solar. Good morning, Mr. Snyder. Mr. Commissioner, do I have permission to proceed?
Yes, sir. Please proceed.
Thank you. Mr. Snyder, my name is Taylor Spear. I represent Vote Solar. I'm appearing from Turner Paget's Greenville, South Carolina office. How are you doing today?
Very well, Mr. Spear. Good to see you this morning.
You as well. I don't think that we've met, but I'm glad to be introduced to you. Thank you for your introduction on the IRP that DEC and DEP are presenting in this case. I have some questions about that. Your title is Director of Carolinas for the IRP and Analytics, correct?
Yes, it is.
Okay, and if you would please illuminate for me the general structure of how the IRP is developed within your organization, and more specifically, who do you report to in developing the IRP, and who reports to you in developing the IRP?
I report to Mark Oliver, who is a witness in this case, and his organization has the IRP and the ISOP organization under one umbrella. However, the IRP, and I think this is important to note, is really a company-wide effort. So we bring in technical experts from around the company. My team is responsible for coordinating the culmination of those. So we have witnesses today from load forecasting, from energy efficiency and demand side management. We have witnesses from the transmission organization, all of, and several other SMEs from around the company. So there's a host of individuals with decades and decades of experience operating the utility that we rely on to bring the IRP together.
Who does Mr. Oliver report to?
That has just changed. He now reports to Swati Daji.
And is there a board level or a corporate approval of the final, say, draft IRP that Mr. Oliver would develop and push up to management?
Our internal practice, I do not believe there is a board approval. The IRP does get presented to senior management, but it doesn't require specific approval.
Would that be a question that would be better directed to Mr. Oliver?
You can ask him as well. That's my understanding.
Okay, thank you. I'm going to turn you to a portion of your direct testimony, and I know that Vice Chair Belsler likes the citations up front, so I'm going to give that now. This is coming, Mr. Snyder, from your direct testimony, page 8, and it's lines 4 through 6. In your pre-file testimony.
If you could just give me 1 minute to get there, I'm sorry.
Yes, sir. Just let me know when you're there and we can proceed.
Page 8, 4 through 6. Okay, I am there. Thank you, sir.
Thank you. In that testimony, you suggest that the objectives of Duke's IRP under Act 62 are limited to balancing only 3 considerations, correct?
No, I don't say that they're balancing just 3. I list 3 general categories.
Okay, and that's system reliability, consumer affordability, and increasingly clean energy supply. Is that right?
That is correct.
You would agree that's not a comprehensive enumeration of the considerations present in the IRP statute.
Yes, and we address all of those considerations later in my testimony. I simply refer to these as a more general statement that most IRPs nationally and our IRPs and the statute itself, those 3 general categories cover most of the more specific language in the IRPs, specific areas in the IRPs that are identified in Act 62, and we get into each and every one of Act 62's requirements with cross references to the IRP.
Vote Solar disputes that, and we can go through that position here shortly. I'm going to go through the statute with you, Mr. Snyder. Would it assist your testimony to be able to review the statute while I ask your questions?
Yes, if you'd like to pull it up, that's fine, or I can look for it.
Better question, Mr. Snyder. Do you have copies of Vote Solar's cross exhibits before you?
I do not. I might. Let me see. Is that rebuttal? Should we save this for rebuttal, Mr. Spear, or do you want to go into do this in direct? It's fine. I can.
And specifically cross.
Mr. Chairman, I do not believe that the companies had access to Vote Solar's cross exhibits. So if Mr. Spear would like to produce an exhibit to be entered into the record, we would appreciate the opportunity to review it. And then if you could put it up on the WebEx, that would probably be the most expedient way for Mr. Snyder to have the opportunity to review it.
Mr. Commissioner, pursuant to the, Mr. Chairman, pursuant to the Commission's demands, all of Vote Solar's cross exhibits were produced, actually, not just to the court reporter, but to all parties on Friday pursuant to what we were instructed to do. So I'm not sure why the companies wouldn't have access to that. I'm happy to rectify that now, but Vote Solar did what it needed to do to make sure that we didn't run into this situation now.
Yeah, and Mr. Spear, we saw your email on Friday. You were the only party that provided a list of the planned exhibits and a link to the commission. We assumed that that was an oversight on your part, which perhaps it was not, but the link didn't work and we didn't follow up over the weekend because we were not anticipating that you were providing all other parties copies of your cross exhibits prior to the hearing, as none of the other parties have done so. And that was not, I guess that would say that was beyond the directive of the commission's staff in the email that was sent about 7:30 Thursday evening. So not trying to be argumentative, Mr. Chairman, but it seems like the most expedient thing is if Mr. Spear wants to ask Mr. Snyder a question about a prospective exhibit that he'd like to put into the record, if he could put it up on the WebEx and have the opportunity for Mr. Snyder to review it and for council to review it, that can move this forward.
Mr. Chairman, I just would like to note for the record, I'm not accustomed to being criticized for transparency.
I don't think there are any, I didn't hear an allegation. I'm hearing what one side believed happened based on the email. We just want you to proceed with your cross-examination in the most efficient way possible. That said, is it possible for you to place your exhibit onto WebEx so the witness and witnesses counsel can review?
Be happy to do that, Mr. Chairman.
Yeah, we're all friends here. We can play nice.
For reference, this is Vote Solar Cross Exhibit 2, and I will be pulling it up on the WebEx screen. Mr. Schneider, are you able to see what I have represented here as Vote Solar Cross Exhibit 2?
Yes, I can see it, and it's very readable.
Mr. Chairman, is it viewable to the commission?
Yes, sir. We can see it. If you would just, yeah, we can see it. Go right ahead.
Okay. Mr. Schneider, do you agree that this is a printout of Section 583740?
Yes, I do.
Okay, and I'm going to turn to, well, first, I think that it would be appropriate to admit this as a cross exhibit at this time. I don't think there's any dispute as to authenticity.
No objection.
All right, no objection to authenticity.
May the cross exhibit be moved into the record, Mr. Chairman?
Yes. Oh, I didn't know you asked for it to be moved into the record. Yes. Vote Solar cross exhibit. Did you have a? We'll just mark it. Vote Solar cross exhibit will be moved into the record as hearing exhibit 2.
Thank you, Mr. Chairman. Mr. Schneider, I'm directing your attention to the statute reference. This is the IRP statute. This is subsection B. And I want to go through this a little bit with you. I know that you're very familiar with the statute as the reason that you are a competent witness and you're here to testify today, but there are some particular points that I want to address with the statute. Would you agree with me, sir, that this mandates that the company's IRP must include several different factors? One is listed A through E here. Do you see that?
I do.
Okay, and I want to draw your attention specifically to subsection E there. And correct me if I'm wrong in reading this, but it says, several resource portfolios developed with the purpose of fairly evaluating the range of demand-side, supply-side storage, and other technologies and services available to meet the utility's service obligations. Within that statute, Mr. Schneider, the question is, how do the companies view DEC and DEP's service obligations?
How do we view our service obligations? To reliably and affordably meet the capacity and energy needs of our customers within the constructs of the rules, regulations, statutes of state commissions, Federal Energy Regulatory Commission, Nuclear Regulatory Commission, several other governing bodies.
Would you agree that at a fundamental level, it would consider the financial health of the companies so that they are able to continue providing retail electric service to South Carolinians?
I can tell you we did not, in the IRP, the financial health of the company was not a consideration.
Correct. And that's sort of the point. But right now I'm just referring to what the companies view as the utility's service obligations. Wouldn't this, naturally, wouldn't the service obligation imply just fundamentally a sense of financial solvency such that the utility can continue to provide retail electric service?
Yeah, that is not a consideration that was brought into this IRP proceeding in any manner that I'm familiar with.
That's the point. And so what I'm asking you is whether or not you consider that a part of the utility's service obligation under South Carolina Code annotated 583740. Okay.
I don't think the IRP statute was intended to mean that.
Okay. I'll turn your attention to subsection H, and I'll pull it down. You agree that part of the company's responsibility in developing a lawful IRP would be to include an analysis of cost and reliability impacts of all reasonable options available to meet projected energy and capacity needs?
Yes. Yeah.
And that's a mandate to include all costs.
Can you refer me which section you're speaking to right here?
Subsection H. I can move my cursor here around so you can see it. Does that assist you?
Yes.
Okay.
Yes. The cost and reliability impacts of all options considered in the IRP should be a component of the IRP. I agree.
Thank you. And the statute also discusses the intervener's availability to receive discovery. Is that correct?
It does.
All right. And I've moved the screen to show subsection C1. What's your understanding of Act 62's requirements for the companies to participate in discovery in the IRP proceeding?
And I think the word reasonable discovery is to permit reasonable discovery in C1. And I think the company has gone above and beyond in my history of the IRP. And I think we provided over 3,200 separate data requests between the two jurisdictions and made sure all parties had access to data requests from both jurisdictions. So I think, yes, there is a standard there. And in my history of doing IRPs, this has probably been the most discovered IRP docket, given the nature of it being the first one in South Carolina. That's understandable. But yes, we provided significant discovery and put significant resources from around the company to reply as timely and as fulsomely as we could.
It is correct, is it not, that DEC and DEPP oppose Vote Solar's request to have the companies pay for licenses to access the company's data modeling? Isn't that correct?
Yeah, I believe that may be addressed in some of our testimony, that is not standard practice for the company to pay for other interveners' models.
And Mr. Spear, I apologize. Let me just briefly interject that is an issue that Mr. Snyder addresses in his rebuttal testimony and not in his direct testimony, which is supporting of the company's IRPs and not responding to other witnesses' testimony. So that this examination should be limited to his direct testimony, Mr. Chairman.
Sustained.
Okay, moving down the statute, Mr. Snyder, I wanted to discuss what the commission is required to consider when they're analyzing whether or not DEC and DEP's IRP is the most reasonable and prudent means of meeting the electrical utilities, energy, and capacity needs. So I'm referring to subsection 2 here. DEC and DEP do not deny that there are a number of considerations for the commission in this proceeding, correct?
Yes, I think we cite these very considerations throughout testimony.
Right, and this is going to, I think, some of the direct testimony that we discussed just moments ago, and we're sort of getting to that titular point now, but let me ask you this, you would not dispute that consumer affordability and least cost are important consideration for the commission in this proceeding?
That is correct.
Similarly, referring to subsection G, another important consideration is, quote, other foreseeable conditions that the commission determines to be for the public interest. Is that correct?
That is correct.
Do you dispute that Vote Solar's purpose in intervening in this proceeding is to support and protect consumer affordability for the company's IRPs?
I believe that's their contention.
Do you dispute that contention, that that is the purpose of Mr. Fetch's direct testimony?
I don't dispute that that's his intention.
Same question with respect to subsection G, other foreseeable conditions. Do you dispute that that's what Vote Solar is here to do, to determine what other foreseeable conditions exist and whether or not they are in the public interest?
That is consistent with their testimony.
Would you dispute for me, or rather in general, that's not for me, will strike that. Do you dispute in general that the word foreseeable does not appear in your direct testimony?
Subject to check.
Do you dispute that the phrase public interest appears only once in your direct testimony? And that's on the very last page, second line to the last, and I'll give the citation there. It's in your direct testimony at page 36, line 8.
Subject to check.
Subject to check, you do not dispute that?
Yeah, I mean, if you've gone and done a count, I do not dispute that we have not used the exact words except one time in my testimony. I think we do a lot. We do summarize these A through G, and are fully aware that the commission has the exact wording in front of them as they adjudicate this proceeding.
Thank you. I'm going to remove the statute from the screen. And one final point from the statute, you agree, correct, that the commission has authority to do any number of things with DEC and DEP's proposed IRPs in this proceeding, including modifying or outright rejecting them?
I agree that they have that authority.
Thank you. Where do long-term risks sit within the considerations that the commission is mandated to review when they are analyzing whether or not Duke's IRP is reasonable and prudent?
It's one of the factors. The commission is free to put weighting on it as they see appropriate.
Would your answer be the same if I made a more specific question on long-term risk being actually stranded assets?
I think the commission can determine risk, and we get into this quite a bit. I'm sure we'll have a fair amount of discussion later in this proceeding on what the definition of long-term risk is, what the definition of a stranded asset is, where those risks lie across all technology types, and how the commission should balance it. So yes, I think the commission will be hearing a lot over the coming days about long-term risk. I know your client has a particular very narrow focus on what a stranded asset risk is. We'll be discussing that. So yes, I think the commission has a lot of latitude under the statute to balance those factors.
You agree with me, Mr. Schneider, that there's no dispute that the commission has the authority to regulate risks that would be associated with a stranded asset?
Commission has authority. I agree with you.
Thank you. I'd like to hear in the company's, your view. I'm getting a little bit ahead of myself, but since you brought it up, you discussed perhaps differing opinion on the definition of a stranded asset. What is your view on what a stranded asset is?
A stranded asset, from a traditional sense, is viewed as any unrecovered balance on that asset at the time of its recovery. I think the commission has latitude to adjust those times of recovery. I think the commission also has the latitude to look at whether or not that asset created significant value above and beyond what's left on the books at the time it's retired. And I think there's several mitigants that we'll get into later in this proceeding that we do not believe we're going to have stranded assets, but we'll save that for later in the week.
Fair enough. And you would agree that the companies in Vote Solar have a dispute on that issue?
Certainly.
Okay, thank you. As director of Carolina's IRP for DEC and DEP, let me ask you just quickly, is there a quicker way to refer to your title? That's kind of a mouthful.
Sure, yeah, that is a mouthful. You could just say Director of Resource Plan, or you can just say Director of Resource Planning. You don't have to do and analytics and Carolinas and all that.
Okay, thank you for that. As Director of IRP or Resource Planning, You are surely familiar with the recent order that the commission put out in the Dominion IRP proceeding. And I'll be specific so we're not guessing here. December 2020. You're familiar with that order?
Yes.
I'm going to pull it up on the screen so we can go through some of it. You agree with me that the commission in that order expounds on Act 62's requirements for reasonableness and prudence, correct?
It does.
Okay. Mr. Chairman, I'm going to be referring Mr. Snyder to Vote Solar Cross Exhibit 5.
And Mr. Chairman and Mr. Spear, just so the record, or maybe the presentation is clear, this potential cross exhibit is not yet on the screen.
Correct. I was going to create a foundation before I start pulling it up. Yeah. But I think I've already done that. So
I think we'll stipulate that the commission has issued an order for Dominion and in their IRP proceedings, and that that order, if the commission wants to take judicial notice of it versus having it as an exhibit, that would be fine with the companies.
Thank you for that concession. And Mr. Chairman, Vote Solar does not have a preference on whether or not it's received into the record because, as Mr. Breitschwart wisely points out, that the commission can take judicial notice of it. But to the extent that it wants it to be in the record, I believe that is a non-disputed issue.
Are you asking that we take judicial notice, or are you asking to enter the exhibit into the record?
Vote Solar doesn't have a preference and would like to please the commission on that score.
I'm indifferent to it.
We'll put it in.
Vice Chair Belzer.
I just note that it looks like this cross exhibit 5 is only portions of the order. I'm not sure if the parties understand that it's not the full order, it's just portions.
And I'll gladly respond to that, Vice Chair Belzer. Quite frankly, Vote Solar was taken aback by the requirement of paper copies. And so there was quite a volume of paper that had to be delivered to the commission in short order. So what we did was delivered an abridged copy of certain voluminous exhibits, but we have given the parties the full record by delivering the actual full and complete record.
Mr. Chairman, and Mr. Spear, that was not a criticism at all. It was just pointing out that it was not the complete order, just so that whoever's online understands if to make an informed judgment of whether to introduce this limited portion or take judicial notice. That was the only reason for my comment. Thank you.
And Mr. Chair, I apologize. I perhaps should have not, in an effort to be helpful, gotten involved. So if Mr. Spear would like to enter his proposed exhibit, which sounds like it's only a portion of the Dominion order, into the record, the companies don't object to that, assuming it is what he represents to be, which I'm sure it is. So thank you, sir.
Mr. Chairman, Vote Solar moves that Vote Solar Cross Exhibit 5 be entered into the record.
All right. Hold on one second. Yes, General Counsel Wessinger Hill. Your microphone is not on.
Sorry. Mr. Chairman, both electronically, the complete copy and the abridged copy have been provided to all parties.
All right. Vote Solar Cross Exhibit 5 will be entered into the record as hearing exhibit 3.
Thank you, Mr. Chairman. And I will be pulling that up on my screen. Mr. Snyder, do you see an abridged copy of South Carolina Commission Order number 2020-832?
I do.
I will direct your attention to page 2 of the abridged version. And I want to confirm with you that in this order, the commission gives greater depth and detail to its understanding of the terms reasonable and prudent within the IRP context.
I'll agree. That's what's on the page.
Okay, and this will help. kind of
Attorney
keep up with
Spear,
that.
if you would enlarge the exhibit, please. Thank you, sir.
I want to ask you, Mr. Schneider, I'm interested in the commission's view and your interpretation of the commission's view of the word prudent. And I'll help you that appears, it's the first word on page 3 of the abridged docket. Do you agree and understand that the commission defines prudent as requiring that Duke, or in this case Dominion, give, quote, due consideration to actual and foreseeable future conditions and risks?
Yes.
Do you have any dispute that this interpretation of Act 62 would apply to the companies in this proceeding?
I think the commission has stated what Act 62 means in the exhibit you have in front of us. I would simply point out, I do think the commission had a different set of facts and circumstances in that case. And so I'm not trying to extrapolate, what those facts and circumstances were. I was not a party to that docket with Dominion. And so while I'm familiar with their order, I would say that, the facts and circumstances of this case are going to stand on their own with the extensive testimony in the record, with the documents themselves, the studies, the testimony of expert witnesses, and the commission has the latitude to interpret the term as it sees fit based on the facts and circumstances in this case.
I think you raised a fair point.
And Mr. Chairman, if I could just object briefly to make the point that Mr. Spear has gone through the statute with Mr. Schneider, is now going through the Dominion order. And I've not raised these objections thus far, but to the extent he's calling for legal conclusions for Mr. Schneider to make, Mr. Schneider is not an attorney. He's not been proffered as one. He's the director of resource planning, as we've discussed. And so to the extent we're talking about facts and circumstances as he just identified, I think that's perfectly appropriate. But if Mr. Spear is seeking to elicit legal conclusions from Mr. Schneider, I think that is objectionable and something that the commission should not allow.
I'll rephrase the question, Mr. Commissioner. I think that I'm able to do that and resolve this issue so there doesn't have to be an evidentiary ruling, if that pleases the commission.
Go ahead.
What I'd like to understand, Mr. Schneider, is did you integrate this understanding of the commission's expounding on the word prudent in your own planning?
Yes, we believe our plans are prudent and in the public interest, and we believe our testimony and the plans themselves show that.
Did this order inform the resource plans that you present in this proceeding?
We were aware of the order, but we developed our resource plans based on our standards that we read and interpret, not on Dominion's. As I said, I think the facts and circumstances, their models, their approach to the IRP were completely different than the company's. So it's hard to extrapolate too much from a completely different case that had completely different facts and circumstances as to, what the facts and circumstances would be in the Duke case. So we were aware of it, but we went to the act itself and line item by line item endeavored with a great deal of resources to ensure we met each and every requirement of Act 62.
Act 62 does not define the word prudent, does it?
I'll agree, subject to check.
But Commission Order number 2028-32 does, correct?
Yes. And
So I want to,
in
go
that,
ahead.
nothing in that order, as I read that sentence that you put up on the screen, that we disagree with.
But specifically, did you integrate into the company's IRP proceeding this particular definition of prudent?
So if I read that, it says prudent, which implies that it gives due consideration to actual and foreseeable future conditions and risks. I believe we're going to have a lot of testimony over the coming days to say we did give due consideration to actual and foreseeable. I'm sorry, you're
There's some information on the screen that looks like some type of Gmail chat or something. You may not want to show that. Attorney Spear. All right, so we're back to the order. Any more questions, Attorney Spear? Is he muted? Attorney Spear, I think you're muted, sir. Attorney Spear?
Yeah, I apologize for that. When you share a screen, your actual controls get a lot smaller and harder to see. So, Mr. Snyder, sorry for the delay there. I'm referring to the last paragraph of the Dominion order. Is it the company's understanding that Act 62 further requires the companies to identify and mitigate ratepayer risks consistent with this paragraph that begins consistent with the purpose?
Yes, I see that.
Do you agree that one of the commission's considerations in this proceeding is to require that the companies identify and mitigate ratepayer risk?
Yes.
And you agree that that's exactly what Vote Solar is attempting to do by intervening in this proceeding and sponsoring the testimony of Mr. Fitch in the carbon straining report, correct?
I think, as I said, we'll probably have lots of discussion on that. He has one risk out of probably 100 risks that a 20 or a 15-year resource plan can address. And Mr. Fitch makes several mistakes, but even with, considering the mistakes, he still focuses on a single risk. And an IRP has a much broader view than the single risk identified by Mr. Fitch. And he conveniently ignores several other risks and with the almost exclusive focus on one particular risk, which I think he's mischaracterized. But I think we're going to have plenty of opportunity. We can continue to go down this path if you want, but I think when we get into rebuttal on Mr. Fitch's opinions, you and I will have lots of discussion.
The companies do not deny in this proceeding that they have intentionally or knowingly excluded financial risks associated with climate change from their resource planning. Isn't that right?
The term you use, financial risks associated with, climate planning? Is that
climate change?
Climate change? That can be interpreted, and I've heard that interpreted about, a dozen different ways. So under some interpretations, we certainly have shown the mitigation is to reduce carbon. We're a national leader in reducing carbon. We have one of the lowest carbon intensity fleets in the nation. We continue to increase our carbon footprint faster than almost any of our peers. So from that respect, I would say that we are fulsomely addressing climate. A different interpretation is physical floodplains changing? And does the company in the IRP address the potential to have to put flood mitigation at a substation, for example? That is something that we're not addressing in the IRP. So depending on your term of and how you're using the term addressing climate change risk, you could argue it either way. But I would say from an IRP perspective, we have taken a very transparent and broad view on reducing carbon footprint, and it's front and center in our IRP.
Well, since we're having apparently a disagreement on language, let's use Duke Energy's, or rather the company's own words. And commissioners, now I'm going to be referring to Vote Solar Cross Exhibit 7, which is a copy of Duke Energy's responses to Vote Solar's discovery requests. Mr. Snyder, as Director of IRP for the Carolinas, you have familiarity, do you not, with the company's responses to discovery requests?
I know we've answered a lot of discovery requests. Have I committed all 3,200 to memory? No, I have not.
Did you participate in answering any of those requests?
Some of them, not, that, like I said, we had multiple subject matter experts from around the company answering data requests. Those do not all come directly through me.
Okay, well, I'll represent to you that what I'm going to show you, as well as the commission, is the company's answer to Vote Solar's data request number 2, and subject to Mr. Breitschwartz's comment, I would ask that the commission introduce this interrogatory, or rather discovery response, into evidence. And that, for reference, is Vote Solar Cross Exhibit 7.
Attorney Spear, if you could enlarge the document for us, please. Any objection to Vote Solar Cross Exhibit 7 being entered into the record?
No objection on behalf of the companies.
Vote Solar Cross Exhibit 7 will be entered into the record as hearing Exhibit 4.
So, Mr. Snyder, I sort of preface this by saying it appears as that we had a dispute on language and what it is that the companies did and did not consider with respect to financial risks associated with climate change. And my intent here is to clarify that conversation and to give us a framework of actually where any dispute would lie between those two things. So in this request, isn't it correct that Duke Energy was asked whether it conducted an assessment of climate risks on the assets, operations, and earnings of the companies? This is subsection A.
I see it.
Okay. You agree that that's something that was asked of the companies?
I agree that that's a question you asked, yes.
Right, and I'd like for you to read the response A.
DEC and DEP object to this request because Duke Energy 2020 climate report was not used in any way in the development of the 2020 IRPs, and therefore the request seeks information that was not relevant and not likely to lead to the discovery of admissible evidence in the IRP proceeding.
Okay, well, I'll ask you that question now under oath. Has the company conducted an assessment of climate risk on the assets, operations, and earnings of Duke Energy Carolinas and/or Duke Energy Progress specifically?
In the context of how it would impact the assets, I am not a part to any such study. You may be able to ask one of our other company witnesses. I think what that response says is in the context of an IRP, and I think this goes directly to what I was saying earlier, which is, could climate risk, change floodplains, and could that, need to be addressed in a transmission and distribution plan over the long haul that would look at that. If the company's studying that, they may be, I'm not participating in that study, so you may have to ask that of another witness. I think the response here means that it is not, such studies were not used in the development of this IRP.
I think you answered that specifically with respect to assets. What about operations and earnings?
I do not, I'm not aware of any, you know, I would say, again, depending on how you define it, you have to be very careful in how you define this. I mean, operations, we looked at a no carbon, a mid carbon, a high carbon price, which would presumably be developed by federal or state regulations that monetize the cost of carbon in the form of either a carbon tax or an allowance cap and trade. And the operations of the fleet change, as you see in our IRP. So under that definition, we have looked at how operations would change, but through taking a price that was developed in policy and then directing how the plants would be operated. So, you know, to some respects, you could say there was operational considerations of different climate regulations that might come to fruition. But in terms of the physical condition of an asset, like I said, you know, whether there's temperature changes for design or flood conditions, you know, the physical impact on a plant, that was not part of the IRP.
Okay, and I think that we can be more
very definitional.
Yep. I think we can be specific on this one. Duke Energy did not provide or conduct or have commissioned an analysis on the incident of climate risk on Duke Energy Carolinas, or Duke Energy Progress's climate risk to its assets, operations, and earnings. That's not something that the company conducted analysis on, correct?
For inclusion in the IRP, it is not. What else is happening in the company, studying that from our environmental group or others, I am not party to that, so I can't testify to that.
Okay.
Whether we are or not.
You would agree with me that the company did not conduct an assessment of climate risk on ratepayers served by Duke Energy Carolinas and or Duke Energy Progress specifically, correct?
We did in the IRP show, and again, depends on, I think, Mr. Spear, how you define climate risk. I think we attempt to monetize climate as a federal policy or a state policy that puts a price on carbon, and we monetize those carbon prices. Presumably, those carbon prices and policy would reflect such studies, but you know, we're in the context of an IRP and looking at how a generation fleet operates through time. The effects that you're talking about are captured in our carbon price scenarios.
Mr. Schneider, please read subsection C on your screen.
As the companies conduct an assessment of the climate risk on ratepayers served by Duke Energy Carolinas or Duke Energy Progress specifically.
Please read the company's response on page 2 for subsection C.
Right. So the companies have not conducted any such analysis, you know, under the earlier definition.
Okay. We're going to have you read subsection F.
As the company assessed the risk of increased property insurance premiums as contemplated in the Duke Energy 2020 climate report.
And the company's response is no.
Like I said, I'm not the witness on that, so I'll agree with you.
Would you, okay. Did someone instruct you or Mr. Oliver not to do those things?
Not sure they would even fall within mine or Mr. Oliver's organization. As I said, you know, the impacts of changing floodplains, changes in weather conditions, go far beyond the scope of a integrated resource plan.
Okay. I've got to make sure that I didn't skip something here. I'm afraid that I might have. Did you read subsection C? Has the company conducted an assessment of climate risk on ratepayers served by Duke Energy Carolinas and or Duke Energy Progress specifically?
Yeah, I think we just went over that and I said, I saw that.
Fair enough. Thank you. So I'm going to take this back now to the Dominion IRP order. Do you remember agreeing with me that that order states, consistent with the purposes of Act 62 and other sections of the Act, the integrated resource planning provisions of Act 62 include requirements intended to identify and mitigate potential risk to ratepayers? You remember that we covered that?
I do.
Okay, so the companies have not complied with that order as to conducting an assessment of climate risk on ratepayers, has it?
It has complied with the order. You're taking the order out of context, Mr. Spear. The Act 62 talks about risks that are IRP related. Operating a vertically integrated utility from generation, transmission, distribution, all the related customer service and functions, financial, rates, rate making, there's a host of issues that present risk outside the context of an IRP. So you're taking, in my opinion, what is a potential study that is not part of any IRP I've ever been aware of in the country, other than to try and quantify carbon prices as a way, as a proxy for how this system would operate differently if there were a carbon price or if there were not. The type of study you're talking about does not have a direct input into the IRP, in the IRP framework. It doesn't mean it's not a risk that the company shouldn't study. It just means it's a risk that's not within the construct of an IRP.
What is Duke Energy Corporation's 2050 goal?
Net zero by 2050.
That applies equally to DEC and DEP, correct?
Yeah, it's the holding company.
Okay. But I want to make sure that I have clarity on that answer. We understand that Duke Energy Enterprise has a 2050 goal, correct?
Yes.
And their 2050 goal is not, rather, the companies don't dispute that DEC and DEP are a part of.
Yes, we look at ours the same way. So where, as you saw in my summary table, we show our various trajectories along that path.
As director of Carolina's IRP, you have familiarity with Duke Energy's 2020 climate report, do you not?
Yes, I do.
Okay. What's the purpose of that report?
Purpose of that report is to reiterate the company's intent that we have carbon reduction as a clear goal of the company. We've talked about in that report our two benchmarks of at least 50% by 2030 with a target of net zero by 2050. We also highlight in the report that to get to net zero is not going to happen under today's technologies nor under today's policies. I think it's consistent with the summary that I put up, that it's going to take technological advancements. You cannot get there with the technologies that are in the ground today. And you need supported policies as well to move you towards net zero. I think that's pretty well established in the report.
Thank you for that. What audience is the report intended to inform?
I would say all stakeholders.
What about shareholders?
Shareholders, stakeholder.
Do you agree that the company's valuation is tied to a commitment to addressing climate change risk?
I think, I don't know about its evaluation. I know it's important to all our stakeholders, including our shareholders, customers, the company.
Are you able to tell me or give an opinion on why the enterprise's commitment to addressing climate change would be relevant to shareholders?
Could you restate the question? I'm sorry. Let me turn my volume up a little.
Sure. I'm just asking you to comment on why the enterprise's shareholders might be interested in the company's attempts to address climate change on a regional level.
And Mr. Chairman, I'd object at this point. We're getting pretty far afield from one, the purpose of this proceeding under the statute, and two, what Mr. Snyder's testimony and even the 400 and some odd page IRPs speak to. There's no reference to shareholders. He's already said the climate report is outside of the scope of the IRPs that the company's developed. So to the extent of what's interested to Vote Solar or to the company's shareholders, that seems beyond the scope of what Mr. Snyder has testified to in his direct testimony.
Mr. Chairman, I would ask for permission to respond.
Please respond.
I'm reading directly from the company's discovery responses. DEC and DEP object to this, and this is a reference on whether or not the 2020 climate report was considered for purposes of the company's IRP. DEC and DEP object to this request because the Duke Energy 2020 climate report was not used in any way in the development of the 2020 IRPs. That's why Vote Solar is here. That's the problem. So what is contained within the climate report is highly relevant for purposes of our position, and the context of that report, the foundation for it in the background is absolutely equally relevant, and we ask that we be granted leave to go into those issues.
Overruled.
As I said, and Chairman, just to be sure I'm okay, you overruled Mr. Breitschwart, correct?
That's correct.
Okay, I want to make sure I'm okay to respond and I'm not responding inappropriately. Shareholders are a stakeholder, as I said, and I think we've, fully said that the company is committed to reducing its carbon footprint. We lay that out in our climate plan, and our IRPs are an independent process that stand on themselves that show that our achievements within the IRP are fully consistent with the climate plan.
I'll repeat the question. Why is it important to shareholders that the companies address a commitment to resolving climate change risk?
Could be several reasons. It could be that there are personal motivations, as you have environmental stakeholders are, that they want to invest in companies that share their personal vision. It could be that they believe that that is in the best interest of the planet. Why does anybody believe? I think we all are striving for the same goal, which is to reduce our carbon footprint. And why any individual, what are the exact motivations? I can't say.
Would one of them be that Duke Energy Enterprises shareholder value is tied to a commitment to resolving climate change risk for the utility?
Mr. Chairman, I object again. I mean, this calls for speculation for what some shareholder of the company is considering in whether or not it invests in Duke Energy Corporation, which is not Duke Energy Carolinas and Duke Energy Progress, which are before you today in these IRP proceedings. So again, this is asking for speculation and Mr. Snyder to consider what a Duke Energy shareholder would consider in whether or not to invest.
Well,
sustained.
Okay. Mr. Snyder? Oh, sorry, the objection was sustained. I'll move on. Okay, so we'll get to the climate report now. Mr. Snyder, you have familiarity with that document, correct?
I do not necessarily have it in front of me. If you'd like to pull it up on the screen, if you're gonna reference,
Yeah, I'll do that, and I intend to spend some time on it, but I want to make sure that as the director of Carolina's IRP, that you've read that document and that you have
I
familiarity
am
with it.
familiar with that document, yes.
Okay. Commissioners, I'm referring to Vote Solar Cross Exhibit 13, which I'll represent to the parties, is the reference to Duke Energy 2020 climate report, and I'll pull it up on the screen. Mr. Snyder, do you not have access to Vote Solar's cross exhibits there in either paper or electronic form?
I do not.
Okay. Mr. Snyder, are you able to see my screen?
I am.
Is what I'm showing you, at least the cover page, correct copy of Duke Energy's 2020 climate report?
It is.
You don't have any reason to, I'll represent to you that this is a complete copy of that document, and it's been attached to others' direct testimony. You wouldn't dispute the authenticity of what
I would not dispute the authenticity.
Thank you. Mr. Chairman, Vote Solar offers Vote Solar Cross Exhibit 13 into evidence.
Vote Solar Cross Exhibit 13 will be entered into the record as hearing exhibit number 5. And Attorney Spear, if you would enlarge the document for us, please, sir. Thank you.
Yes, sir. Mr. Snyder, I'm going to skip to the executive summary. The first paragraph there, would you agree that that is a pledge on behalf of Duke Energy to address climate change risks?
Yes.
And Duke Energy represents in this document that it's going to double down on its effort to address climate change risk.
Can you show me where you're referring to on?
Sure. Right here. We must double down on the hard work that will inform the technology, pace, and cost of the transition.
Yes.
And additionally, Duke Energy reports in this document that it's leaning into the challenge. And that begins on the second paragraph. The report discusses how we are leaning into this challenge and addressing climate risks.
Yes.
I will direct the witness and the commission to page 6. If you're actually looking at the documents, commissioners, there is a heading, or rather a footer, that was put on there with page numbers in it. And if I reference a page number, that's the page number that I'm going to be shooting for. So now I'm going to page 6. And I want to draw your attention, Mr. Snyder, to the first paragraph that's on the right there. Is this paragraph an acknowledgement that this commission is likely to have an impact on the way the companies achieve their 2050 goal?
Oh, yes, this commission will have an impact. Will have a role in improving the resources.
And approving lots of other things as well. Whether or not those.
Absolutely.
Okay. All right. Commissioners and witness, page 9. Well, I'll direct you to page 8, I guess, first. This is a discussion of the board committee oversight and development of Duke Energy's 2050 plan, correct?
Yes.
And the next page, Duke Energy has committed an immense amount of resources, correct, to addressing the risks associated with climate change, including authorizing 6 committees on the board to address that risk. I'll make it smaller. I'll just 1, 2, 3, 4, 5, 6 committees have varying authority and autonomy to address climate change risk.
Correct?
Would you agree that the company's climate change risk affects all of these factors? Corporate governance, finance and risk management, operations and nuclear oversight, regulatory policy, compensation, and even compensation, but and an audit committee. Climate change touches all of these high-level issues.
Our climate, yes.
The first sentence there, the day-to-day direct management of climate and carbon reduction policies is the responsibility of the company's federal government and corporate affairs team. Are you or Mr. Oliver a member of that team?
I am not.
How about Mr. Oliver?
Not to my knowledge. You can ask.
Okay. Are you aware of any witness that would be presenting testimony on behalf of the companies that would be a part of this team?
I am not.
Commissioners and witness turning to page 11. And this heading here, accelerating our carbon reduction goals. Do you agree that this report is an acknowledgement on behalf of Duke Energy that addressing climate change risk is a long-term problem?
I agree.
Next page. I would ask you to read into the record, please, sir, the first full sentence that appears on that page. If I need to make it bigger, happy to do that.
Are you at implementing?
Yes, sir. Thank you.
Here. Implementing this bold vision requires us to begin planning and executing now. The choices and investments we make near term will be foundational to achieving net zero by mid-century.
I think that's something that Boat Solar and the companies agree on. What is your understanding of the term path dependency?
You can use that term a lot of different ways. It's your path, the investments you make today, how they influence future investments as you move through time.
Would you agree with me that these two sentences are an acknowledgement on behalf of Duke Energy that resolving the long-term risks of climate change is a path-dependent process?
Yeah, it's, like we said, it's long-term, and I think our IRP shows multiple pathways with different trajectories, which is very, instructive, and we show, like I said, 6 different portfolios. I think I showed that in my overview. Each have a different path and trajectory towards carbon reduction, and you can use pathway, you can use trajectory, you can use pace. There's lots of words you can use, but yes, you need to be striving towards at least 50% by 2030 is our commitment in this report, and toward net zero by 2050.
But this is just sort of one opportunity where Vote Solar gets to use its own words. So I want to understand the answer to your question. Is this an acknowledgement on behalf of Duke Energy that resolving long-term risks associated with climate change is a path-dependent process?
Can you give me your definition, please, Mr. Spear, of path-dependent?
Okay. So when I say path-dependent process, I mean one in which if we looked into the future, say 2050, that arriving there would be less based on conditions that exist at 2050 than it would on conditions and events that would have occurred behind that time.
Certainly, I think that's exactly what our IRP shows, is you have events happening over the next several decades that are putting you on different trajectories.
And there's a snowball
In
effect.
2050, you know, you have to take action over the next 3 decades, and that's exactly what we show in the IRP.
Well, the Duke Enterprises climate report suggests that you have to take action now, correct?
We are taking action now. We've retired more than half our coal plants in the Carolinas. We're one of the lowest carbon emitting resources, utilities in the country. We show that on the executive summary of our IRP, where a national report lists Duke as one of the lowest carbon intensity utilities. That didn't happen by accident. That was path-dependent actions that have taken place historically to get us to be a national leader today. Then we show in the IRP 6 different portfolios that continue that pathway, which is why we're able to meet a 50% from 2005. We're a leader in nuclear generation. We're a leader in solar. So yeah, it's path dependent. It's paths we've been taking and paths we continue on.
Commissioners and witness, I'm referring to page 13. Excuse me. Big heading here, Mr. Schneider, risk management. I want to talk about this. The 2050 climate report is an acknowledgement by Duke Enterprise that it is integrating climate risks in its enterprise risk management process, correct?
Yes, it is.
Can you comment on what that looks like for the commission?
I am not the head of risk management these days, so I cannot.
Do you know what enterprise risk management is?
I do.
Will you tell the commission, please?
It's a group within the organization that looks at risks that face the organization and quantifies them and develops plans to mitigate them.
But you don't dispute that climate change is one of those risks?
I do not.
Okay. The next paragraph, Duke Energy performs a comprehensive enterprise risk assessment on an annual basis to identify potential major risks to corporate profitability and value, including risks related to climate change. Correct?
Correct.
So this is an acknowledgement that climate change affects corporate profitability and value.
Yeah, I think I just gave an example of, you know, if a flood takes out a substation and that introduces an expense, that could be something that we would not want to happen. So there are lots of aspects of climate change that present risk for the company. And I'm simply here saying that the IRP is not where risks of climate change in the way you're defining them are quantified. It's a corporate global risk that's being addressed. The IRP has a role in reducing our climate footprint, as we just spoke about, but some of these risks are well beyond the scope of an integrated resource planning process.
Despite that, you've already admitted that some of those risks would be pertinent for the commission's consideration in developing an IRP. We went through the statute, Mr. Schneider. I think that what you're saying.
I disagreed with you, Mr. Spear. I'm glad you brought it up. Just to be clear, that statute, when it says risk, doesn't mean every risk facing the corporation as a holistic corporation. It means the risk within the construct of an integrated resource planning process. And to my knowledge, the type of risk assessment you're talking about does not exist within an integrated resource planning process with other utilities that I'm aware of. I think you're extrapolating across something that is not consistent with the Act. The Act was not assuming that the commission should consider any risk facing the company and then pull that risk into an IRP proceeding. You're reading from the statute under the IRP section of a more global statute.
Would you agree with me that policy
in the context of an IRP?
Would you agree with me that policy risk of climate change is a concern to the companies?
There are aspects, we do have several scenarios and sensitivities on carbon pricing. So from that viewpoint, we are looking at the risk. And that is the viewpoint that the commission, in my opinion, having done this again for a lot of years, that's the limit of the risk assessment with respect to climate. Some of these other risks you're bringing into this docket are not appropriate in a resource planning docket.
That's your narrative and you get to speak, so I respect that. Now, I'm referring to page 19. Economic risks. Do you agree that the climate change report is an acknowledgement by Duke Energy that climate change presents considerable economic risks to the enterprise?
I see it. Yeah.
Do you agree that that's what this is?
Yes.
And part of that comes from regulation, such as regulation that would be developed by this commission, correct?
Certainly the commission has the ability to regulate.
Has the ability to regulate economic risks.
Again, economic risk is a broad term, so they certainly have, you know, authority over our rates, our investments, transmission, distribution. We bring them before them in a rate proceeding. I think the real question is, what economic risk are we talking about in the construct of an IRP proceeding versus the, you know, holistic authority that the commission has over multiple aspects of the company's business?
The 2020 climate change report is also an acknowledgement of the risks from stranded assets associated with climate change, correct? And I'll direct you to this paragraph here in answering that question. I'm sorry. Did you say yes? I just maybe misheard you.
Yeah, I agree with what's on that page.
Okay, thank you. Well, that's not the question though. You agree with me that what's on the paper is an acknowledgement by the enterprise that these challenges exist.
Yes. Yeah.
Thank you. Thank you. We're going to move through this a little bit more quickly, which I'm certain that everyone is happy to hear. But I want to direct your attention to page 33. Okay. Are you familiar with this term, cautionary statement regarding forward-looking information? Have you seen that before?
Yeah, general.
And as a publicly traded company, Duke Enterprise has to make certain financial disclosures. Is that right?
That's correct.
And this is sort of a disclaimer on information that might be contained within those disclosures to say, hey, there's a lot of uncertainty in the future. We can't know everything to the extent we're making a financial statement. It's based on the best information that we have at the time of making the statement, right?
Yes.
Mr. Chairman, I'd object. Again, this is far afield from the company's IRP, and Mr. Schneider has already testified that the climate report is not something the company considered in developing its IRP. So cautionary statements and boilerplate language from this report seem pretty far beyond the scope of his testimony or the purpose of this proceeding.
I tend to agree. Attorney Spear, could you help the commission understand the point you're trying to make?
The point that I'm trying to make is that all of these considerations are a great concern to the enterprise. And as has been admitted, without a lot of qualification, that this stuff was not considered in the IRP. The commission is going to have to decide in this proceeding whether or not Vote Solar or Mr. Schneider is correct and that should have been done. As I understand it, that's not been decided today. It's certainly what Vote Solar argues, And we are attempting to create an evidentiary record to support the decision that we want from the commission in the event that it determines from Act 62 that it has the authority to regulate any number of things, including financial risks associated with climate change. This is an open question, and we ask to be permitted to present evidence on it.
And Mr. Chairman, just very briefly, if it's helpful, the company would stipulate that the climate report speaks for itself and that these words are on the page within the climate report. And Mr. Snyder, I presume, doesn't know a lot about these cautionary statements at the very back end of this climate report and can probably just read the words on the page without providing a lot of helpful context to the commission. So we would stipulate that this report was issued by Duke Energy Corporation and that what it states in terms of cautionary statements are accurate and are the positions of Duke Energy Corporation as represented in the report.
The response, Mr. Chairman, is I've not asked Mr. Snyder to read the words. I've asked him to comment on whether it's acknowledgement from the companies that these conditions are true and exist. It's different. It's different.
And so essentially, it sounds like you want to ask him questions related to what the company did not consider in their IRP.
Correct. And the point I'm trying to make is that this information is considered in all parts of their operations. This was addressed in my opening statement. Yet, again, it's by Mr. Snyder's been clear. These risks are considered in the ERM process. I think we're going to get to it later. They're considered in the ISOP process. They're certainly considered in their financial processes and disclosures, but all of a sudden they're not considered in the IRP. That's what concerns Vote Solar.
No, they're fully considered within
Well,
the
Mr. Snyder, wait, if you would wait.
Sorry.
Let's try to get through this evidentiary issue. Attorney Spear, I never want to limit a lawyer's opportunity to make their case. My concern is that if you're going to go through a laundry list of items the company did not consider in their IRP, I don't know if we're ever finished.
Okay, that's a fair point, and I don't want to monopolize time. And Mr. Chairman, you certainly have the discretion to tell me what to do with it. So,
well, I would just ask that you. I see what you're trying. I think I understand what you're trying to do. But I would just ask if you could figure out a way to clearly, concisely, and succinctly elicit the information from the witness regarding what the company did not consider in their current IRP. I think it would move the process along. That's what I would ask from you. I'm trying to give you a little bit of leeway here.
Thank you very much. And point well taken. But I do have to stress here that in Vote Solar's view, it's already established what the companies didn't consider. The point here, and this is a very important one, is that these factors are of high importance and well considered in other parts of their operations. So it's not what the IRPs don't say, it's what they could have said. So,
I'm going. So I understand that, and obviously, what you're trying to do is not evidence. You're just arguing an evidentiary issue here. If you can get Mr. Snyder to agree with you on that, I think it could possibly have some weight. Who knows how much? But if it gets to the point where you all are just going back and forth on positions, then I think you need to move on. So I'll give you a little leeway to try to elicit that information from the witness.
Thank you, Mr. Chairman. I will conclude my questioning on the climate report. Thank you. As Director of Carolina's IRP, Mr. Senator, do you have any familiarity with the Duke Enterprises financial filings, including the 10K?
I have general familiarity. I'm not responsible for their preparation.
Fair enough. But you understand this concept of cautionary statement regarding forward-looking information, and you would not dispute with me, correct, that Duke Enterprises makes certain disclaimers of information that would be contained within financial statements, correct?
Correct.
Okay, and then So what I want to do is establish that some of those disclaimers were made in Duke Enterprises financial disclosures. So
Mr. Chairman, I apologize. You made a very good point a moment ago that Mr. Spear should be asking questions and not making arguments or presenting evidence. And so while I appreciate what he wants to establish, I think that's most appropriately done through question form versus statements. This has happened 3 times now, and I've not raised it on the first 2 times, but I would just object on those grounds.
Sustained.
Mr. Schneider, I would direct your attention to Vote Solar Cross Exhibit 12. And I'll pull it up on the screen here. Let's see if I can do that again. Do you see Vote Solar Cross Exhibit 12, Mr. Snyder?
I do.
Okay, thank you. Do you understand this to be an abridged copy of Duke Energy Enterprises Form 10K?
I do.
All right. And I would ask that the commission accept Vote Solar Cross Exhibit 12 into evidence on that ground.
Vote Solar Cross Exhibit 12 will be entered into the record as hearing Exhibit 6.
Thank you. And for the record, I'll be referring to page 4, and I'm going to move through this more quickly than I intended to, which is a point well taken. Mr. Snyder, again, we see this comment about cautionary statement regarding forward-looking information. And so again, you agree that this is essentially a disclaimer of information contained with the financial statement, basically saying, hey, we can only make financial disclosures based on the best information that we have at the time the disclosure is made.
Yes. Yeah.
Okay. And some of those risks that might change the analysis include climate change, which you see on the second bullet point right there, correct?
No, not correct.
Okay. So I'll read that just to make sure that we're on the same page. Do you see this?
I do.
Okay. So does that change your answer?
No. You asked if it would change my IRP analysis.
If
Change
that's
the analysis.
okay.
I'm assuming you meant the IRP's analysis.
No, sir. I'm just talking about the financial disclosure.
Oh, okay. So
yeah.
does it say that that's part of the financial disclosure? Yes. I thought you were asking me if that would change the analysis that we did in the IRP. And that's what I'm saying no. And you pull up a great page, COVID. COVID has several aspects to the company's operations. They aren't all addressed in the IRP. The load forecast may have some short-term ramifications from it, and you could say that is germane in the IRP. The cost of COVID mitigation, lost work time, that's not in the IRP. That's a great example of climate. There are several elements of climate that are not IRP related, and you can't put them all into an IRP docket any more than you would bring every element of COVID into an IRP docket. So when I say the IRP doesn't include it from every aspect of climate change and how it could affect every aspect of the business. It clearly does include carbon prices at multiple sensitivities to drive us to a lower carbon output. And it includes several pathways to do that. And that's the appropriate context for climate risk within an IRP. The appropriate context for climate risk in an IRP, as stated in this financial statement, has a much broader meaning. And it seems like we're trying here to tell the commission every aspect of climate risk should be in the IRP, just like every aspect of COVID should be in the IRP. And I'm simply saying the IRP addresses it from the standpoint of a resource planning process and that there are other aspects of climate risk that exist outside of a resource planning process. So this was a good illustration of that.
Thank you for that answer. I'm gonna shortcut some of this so we can move on to other important issues. Mr. Snyder, are you involved at all in the company's applications for certifications of public necessity and convenience?
Yes.
You're aware then that the companies use their IRPs as evidence in those proceedings when they seek approval for new gas plants?
It's one piece of information that gets presented amongst much information, but yes.
In other words, the IRP process is not academic, correct?
No, and I don't think we've said it's academic. I'll agree with you there.
Yeah, it has real consequences for the utility's actual generation portfolio.
It is definitely used as a guide towards the investment, yes.
Are you aware that a discovery response issued by the companies in the North Carolina IRP proceeding revealed that Duke intends to issue an RFP and this year, Q4 this year, for nearly half a gig of new combustion gas?
Could you pull that discovery response up, please?
I don't have it. I'm asking you
So
whether.
no, then I'm not aware.
Do you have
The one you're talking about.
Do you have a reason to dispute that statement?
I would want to see it in context, see the full response.
Would any of Duke witnesses that will be presenting during the application process be able to answer that question if you know?
I think any witness would want to see the complete answer so that they can answer in the context of the complete answer. And if you want to break with me again, Mr. Spear, on rebuttal, I'll be happy to take a look at it.
Okay. Nothing further. Appreciate the witness and the patience of the commissioners in dealing with these important issues. Thank you.
Office of Regulatory Staff.
No cross-examination questions from ORS, Mr. Chairman. Thank you.
All right, redirect.
Thank you, Mr. Chairman. Very briefly, Mr. Snyder, a few questions for you. So you and Mr. Spear covered a lot of ground, and you started with the IRP statute. And so I think what might be an effective way to redirect you is to start where we started in your introductory summary, if I could, which is with this portfolio results table. Do you recall questions, and this is in your Exhibit 2, which has been entered into the record at this point. Do you recall questions from Mr. Spear about the IRP statute and how the company developed their IRPs under that statute?
Yes.
And he asked you specifically about whether the company evaluated the cost and reliability impacts of developing the resource plans in the IRPs. Can you please articulate for the commission, using this portfolio results table, how you evaluated cost and reliability impacts of the 6 portfolios the company has presented encompassing its resource plans?
Yes, we have. We've looked at, I'll start with line 1. Again, it's from the construct of an integrated resource plan. We're looking at 6 different portfolios that have a range of costs involved with them, including the cost of carbon. And so where you're seeing on line 1, the 2030 and the 2035 percentage reductions from a 2005 baseline. I'll start with the fact that each one of those, since Mr. Spear was going into the our climate commitment, each one of these plans conforms with our climate commitment by reaching at least a 50% reduction in carbon by 2030, and then also shows the 2035 trajectory. So that, back to his pathway discussion. Then within that, there is the cost elements, including the present value of revenue requirements and the transmission costs, for example, included in that. All of these portfolios are developed in order to maintain adequate, reliable reserves. So that's reliability is built in to that plan as well. And, to clarify, these do not, we have both, and we'll get into this, I'm sure, throughout the week. We put carbon in as both a tax, so where you can explicitly count the cost of carbon, and we put it in as a shadow price to say, if I just operated under an allowance or shadow price, how would the system operate differently? And then we've showed the cost of either option throughout the IRP. So the way in which we've quantified carbon costs and carbon risks are to show the different pathways or trajectories along with different carbon prices. And this is just one summary table that shows how the costs and of increasing the trajectory or going at a quicker pace in carbon reductions, how those change from one portfolio to the next.
Thank you. And do you recall Mr. Spear had some questions about whether the company's IRPs assess the risk of climate change, or more specifically carbon, on ratepayers? Do you recall those questions?
Yes.
And can you explain, using this summary table that kind of encapsulates the IRP, how the companies evaluated the risk of climate change and the cost of various portfolios that consider carbon in various ways on the ratepayers?
Yes. Again, within the context of an IRP, carbon is viewed as a potential cost through policy that will impact customer revenue requirements, customer rates directly, but also it will change the types of investments the company makes. It will change the way the system operates. So a carbon price, whether it's an explicit price or whether it's an allowance price, will change how the fleet dispatches and what the production cost of the fleet will be through time. And so again, very importantly, in the context of the IRP statute, not the global managing the entire company regulations that the commission has authority over, that's how it's incorporated into an IRP. So we see difference in capital investment, difference in production cost, and then throughout the IRP, we talk about what the carbon cost itself could be under various potential carbon futures.
Thank you. And you spent a lot of time and kind of went through a number of exhibits with Mr. Spear where he was trying to elicit what the companies did or did not consider in developing the IRPs as it relates to climate change, climate risk, the cost of carbon emissions on the system. Can you just explain to the commission how you develop the IRPs, the role of evaluating, maybe just make it simple. What did you consider in developing the IRPs, and why do you feel like that was appropriate under Act 62?
Yeah, we looked at every risk factor identified in Act 62, including environmental and climate, and we introduced sensitivities and scenarios and stresses on carbon as a way to evaluate the potential impact, again, within the construct of the IRP. I want to be very clear, there was a lot of procedural debate going back and forth. While the company did not rely on the specific inputs from the climate plan to develop its IRP, the IRP is wholly consistent with our climate plan and our climate commitment. So they are not done without knowledge of one another. In fact, I think the IRP provides useful insights into a climate plan. as to what's achievable and at what pace, and what it costs to go to a faster pace, and maybe what future policy and technologies are going to be required. So while they were done independently, they are not done. They are wholly consistent, and I just wanted to make sure that nothing on the record would indicate that the IRP isn't wholly consistent with our climate report.
Thank you. Mr. Spear also asked you some questions about whether there were stranded assets that would arise if the company didn't move fast enough to address the climate risk. And I believe you said that there are not stranded assets in the IRPs, but can you just clarify that for the commission, and maybe specifically based on the 6 portfolios presented here, whether your perception on the comment on stranded assets?
Mr. Chairman, Vote Solar, Taylor Spear for Vote Solar, that's a highly leading question. This is his witness.
I'm glad to rephrase. Mr. Snyder, do you recall the discussion about stranded assets with Mr. Spear?
I do.
Based on the IRPs that you've developed, could you speak to that discussion?
Yes, and again, I think we'll hear a lot about that throughout the week, but we believe our IRPs are fully developed without presenting stranded asset risk. We talk a lot about the sensitivity, the options to go forward, the mitigants that can be used. We talk about the value created from all of our investments and a diverse array of investments. So we do not believe the IRPs are introducing stranded asset risk. And I hope nothing I said to Mr. Spear earlier would indicate that the IRPs envision that.
Do you recall Mr. Spear asked you some questions about the Dominion order and had you read some language about the commission statements on prudence as it's addressed in that order?
I do recall that line.
And I believe we had a discussion about the fact that you were not an attorney and you were giving your general perspective about what those terms mean and your general understanding of that order. Do you recall that?
I do.
And can you give the commission your perspective, as this is Duke Energy, Carolina's Duke Energy Progress's first integrated resource plan proceeding under Act 62, how you think the commission should consider the Dominion order as opposed to what the commission should do in this proceeding, reviewing the company's IRPs under Act 62?
Yes, and again, I have reviewed some of the Dominion order. I've scanned it. I really believe the facts and circumstances in that case are just foundationally different than the facts and circumstances in this case. The models we use, the effort we went to, the resources put into this, the number of interrogatories we've answered are just present a different case for this commission to consider. And so, they may take judicial notice of what happened in the Dominion case. In my opinion, we have a completely different set of facts and circumstances in this case that I would ask the commission to evaluate on their own merits without, subject to the evidence in this case. And that's what I was trying to refer to with Mr. Spear, and as opposed to reverting back to a different case that had completely different facts and circumstances where they may have had more substantial issues in front of them.
Thank you, Mr. Chairman. That's all I have.
All right, it's lunchtime. We're in recess until 2:10.